He said Charlie.
Yeah.
7.
Okay.
Is that all you guys? Is that done?
Yeah, that's all you need, right?
Yes.
Okay.
Miguel from afar.
Yeah. Oh,
I remember it was one of the first thing.
oh yeah.
One of them.
I really
Not the order.
I don't care who. You put them on my desk. You want an update? Okay.
Sleep good last night? Yeah. Oh, dang. I slept great.
Yeah, coyotes like
oh, okay.
howling at the goats all night.
Yeah.
1 minute. I found the people in the bathroom, so I'm not going there.
My goats show way too much of my life.
Oh, really? It's warm out here. Humid.
No kidding.
I'm like,
The humidity is killing us.
yeah, it's
Couple weeks of that.
okay.
That's been nasty.
I walked into the Jack in the Box and I saw that they have all these air conditioners, like portable.
Fans are going.
Yeah, I was like, wow, okay.
I walked out to walk the dog at 4:30 on the first day of humidity, and my glasses fogged over.
Oh.
4:30 in the morning.
Yeah, okay. So it's not just me. I'm like,
No,
okay.
It's everybody.
Okay.
no.
Yeah, and then the electrical bill goes up to about $1,000 a month.
Oh my goodness.
Because the air conditioning got to be on.
Here in the building.
Yeah.
Oh, at the house.
Oh.
The building's a little more than that.
Are you serious?
That's where ours was at my house when we lived in the desert.
Did you bet?
We've only a couple months.
He's living like Washington.
Very close to not on time, BB. Be here 5 minutes before we start, okay, everybody? Because we don't want to be fumbling around. We want to get started. Now we're going to have to wait for BB to get herself organized. Yes, just sign in.
See, if we were a class of 100, we wouldn't even have noticed.
Hey, in BB's defense, yesterday I was late, so.
And I was also here.
Well, it's not really.
Those are unrelated events.
It's not really for defense. It's like we don't need confessions. Yeah, it's just the first night.
And it might be because I was in the building.
No.
Does that help me out?
You-
No.
If you need extra time in the building, build in extra time.
Okay.
I tried.
I think everybody was here 2 Saturdays ago when I went over the syllabus.
Yes.
Miguel, were you present when I went over the syllabus? So I'm not going to do that again. That's the first thing on my list to catch anybody.
Can you hear us here, Miguel, okay? Okay,
Yes, I can.
good. Just want to make sure.
You have a sign-in sheet. Oh, I'm sorry. I handed you the wrong sign-in sheet. No, don't sign. Sorry. I will put you as present. There's a sign-in sheet that you will find that you sign in on. Then we have a second list of the names, which I accidentally just handed to BB, where I keep track of your participation because you're graded at the end of the semester. 10% of your grade is participation. So that helps me keep track, and then it goes on file so that if anybody questions, I didn't get 10% of my grade, wasn't like a 10 for participation, and I was participating all the time. We can pull it out and see, yeah, you're right, we're wrong, or vice versa. For those on the screen, Miguel, I actually put you in as present, so not to worry. So there's the sign-in sheet for you.
I'm responsible to turn in the sign-in sheet.
So I wanted to know from each of you, what do you know at all about criminal law and how do you know it? Just so I can get an understanding. So So to make you all nervous, we'll start with Miguel.
Okay.
Very good.
Hi. Okay, so I guess the only thing I know about criminal law would be, it's an unlawful act that is.
Well, don't define it. Just how is if you have that information? Have you served on a jury before? You have an undergraduate degree in criminal justice. Your dad was a cop, and you talked about it around the family. Whatever it might be.
No, I actually worked with my uncle at his law firm, and he deals with criminal law.
Okay. Criminal defense then.
Criminal defense, yes.
Okay. All right. This is me learning, everybody. David.
I don't know a lot about criminal law. I know that I've known some people that have been in some trouble. They've been incarcerated and never a place I wanted to be.
But you haven't gone to visit them in the jail. You haven't gone to the courthouse during the for any purpose.
I have spoken with them on the phone. I have not gone with them here in the other state. But I have had a few jailhouse conversations on the phone with them.
They're all recorded, by the way.
Yes, I know. I didn't say anything that was inappropriate. And but I'm interested in the course and the material, and I'd like to see what I can learn from it.
Okay, great. Don't tell me. Great.
Yes.
Okay.
Yeah, in terms of procedure, I'm as green as they come. I can't tell you any of the definitions or anything like that, but in terms of understanding, like, crime is when punishment needs to be laid out. I've read all kinds of theory, all the way from Socrates' Apology and to Hobbes and whatnot. So a lot of theory and a lot of old dusty books.
He's a philosophy man.
Yeah, so this is in the course of your schooling.
Yeah.
You're not at home in front of the fireplace enjoying reading Hobbes. Perhaps Locke. I would understand Locke, but
yes.
Locke.
No. Yeah. I guess I'm revealing too much of who I am in the background. But, yeah. So that's where I kind of get it from, and that's what my interest is.
Okay. And Bibi.
Well, I've actually taken this class before, but I didn't do very well. So
In another law school setting.
yeah.
Okay.
So hopefully, some of
We'll
it
fix you.
has been redeemed.
Fix you. Because if she needs to be fixed.
She didn't do well.
And then I also taught you most of the Felix trial.
Okay,
So
that would be interesting. Okay, so wait. By process elimination. Charlie.
So my name is Charlie Rodriguez, and like I said,
Work for the courts.
I work for the courts. I started in 2001, and when I started there, I started as a general clerk, kind of more or less filing.
In the file room then?
Yeah,
In the
and then
public
I worked. Yes, and then in 2004, I got promoted to the courtroom, and I've been in the courtroom ever since. I currently work in the criminal department, so my experience with law, I don't really know. I mean, currently, I'll tell you about. We're in a murder trial right now, and some of the elements or some of the issues for the jury is third party culpability, where we have two teenagers that just graduated. And I can talk about this because I'm not on the jury.
Right.
But
And no one here is.
And no one here is. But this young man, they had, I guess in high school, they had issues. And it spilled over into the street, and they were going to meet up for a fight, but the guy wound up getting killed. So where the third party culpability comes in is there was one of the guys, the defendant, his friend, he went on like a murder crime spree for a period of like 6 months. So the defense is that, of course,
Some of the dude did it.
kind of, so
That's the defense.
yeah, so it's
Some
very
other dude did it.
basically, yeah. So it's a very interesting case, but like I said, that's probably my extent of the exposure to criminal law, but I do look forward to recognizing the elements and applying the facts and go from there.
You've seen jury instructions.
Jury instructions, well, I could tell you the basic 100 series, the 200 series, and then, yeah, so I'm very fortunate to be in that kind of environment and to assist my judge. I adore, I don't adore, but going to work is fun every day. And I can't say that I've ever had a job that quite as fun as where I'm at now. And I've been with Judge Steve Malone probably for about 5 years.
Was it Judge you?
Steve Malone,
And which department is it?
Department S12. So, and we call it fast track, where all we do is trials that vary from the range of anywhere from felony cases, of course, 3 days to maybe 2 weeks. Anything above 2 weeks, we try to farm out to our long cause trial departments. But so far, I want to say in just the last 5 years alone, maybe more than 100 trials I've been part of.
So the trial that's currently in place.
Yes.
What year did that crime occur?
That occurred in 2016.
So that case is 3 years old,
It's 3 years old.
and now is going to jury trial,
It-
and the freshly graduated high school teens of 3 years ago have been in custody ever since.
Yes. And now they're adults, and we just swore in the bailiff today, or I did, as part of my duty, and the jury is already asking for readback. So it's pretty interesting to receive, to see the whole process actually. But I'm more excited about learning actually, from this side,
So Charlie, be honest, as you sit in the courtroom every day for 5 years and you watch the prosecutors and the defense attorneys and the public defenders appear in court, do you say to yourself, they can do that, I can do that?
Actually, and I am being honest, but I think that helped me in applying here. It gave me the courage to say that I could do this. So I think without that experience, I never would have applied or thought law school would have been possible. But yes, it is achievable. And one thing I do notice is that I can tell who's prepared and who's not prepared. So that makes a huge difference.
Preparation is different.
Key, yes. So, but like I said, I look forward to learning and being
But here's a tip for you. Everything that you know from the courtroom,
throw it
put
in.
on one side. Don't throw it away.
Okay.
And just go step by step with us here. Eventually it all joins up, but it probably joins up after you take the bar exam, and you will have a wealth of experience from sitting in trials that most people don't have, but you don't want to start writing about that when we're having you do the basics here, because you'll mess yourself up.
Got you.
So
Thank you.
just separate that out, and it's fine. I mean, you can always be informed about what's going on, but just take it one step at a time here, and eventually you'll catch up to where you already are.
Okay.
Because part of the benefit is the third-party liability in a murder case is one of the more sophisticated rules that we'll get to 6 months from now. And you're seeing the application of it, but we want you to learn the rule. So the benefit is when you've put it over here, you go, oh yeah, okay, so that's what they were talking about.
Got you.
But don't let that rule you as you learn the rules.
Okay.
Okay?
So just put everything I know aside.
Just
For-
to the side.
To the
Hold
side.
it in abeyance. With last year, we had a cop. So of course, he's got all kinds of street experience and whatever. But whenever he got a little bit flummoxed, it was because he was trying to use that to
Here.
deal with
Okay.
this, and I'm trying to separate those things out. And you'll be fine.
Thank you. Thank you.
There won't be much that you haven't heard of here.
Melvin, your experience.
Well, as everybody knows, I have a herd of children. I have 2.5 kids whose middle names are pretty much bad judgment. And so as a parent, I have,
You've had some brushes with the criminal justice system.
yes, I have spent tons of money on lawyers defending their bad judgment.
Okay.
I don't think I'll be able to ever do it because as I tell my kids, don't tell me because I'm going to snitch on you. And so, yeah, I've dealt with juvenile, public defenders, private lawyers, and lots of different ones.
You're the
And
lucky
also,
dad.
as a non-biological parent, their biological parents often times are in the penal system, and so I've seen them work their way through their issues also.
All right. Thanks.
I don't have any criminal law experience. Mainly, I've seen the effects of crimes on,
No traffic tickets?
well, yeah,
Okay.
a couple of
A brief
speeding tickets.
conversation with the law enforcement officer at least.
I do have a brother who, because of some acts, he was punished. He did go to jail and he was deported. So I have that experience, but pretty much.
Okay. And Renee, just tell me one more time how you pronounce your last name, because I really want to give it the French pronunciation.
Des Jordan,
Des Jordan.
exactly how it's spelled. I know everybody wants to try to pronounce
Des
it.
Jordan.
Yeah,
Yes.
exactly. Well, I'm Renee. Criminal law has always intrigued me. I just go with mainly the paperwork side of it for the attorney I work with and a couple other attorneys in San Francisco and Sacramento. I do the paperwork side, that's pretty much it.
And they practice criminal defense. Okay.
Perfect. So we have two guests here, so you don't wonder who they are. So Paul, introduce yourself.
My name is Paul McKee. My experience with criminal law is I work with an Indian tribe. That's a joke. By the way, but no.
I said you're going to, he really just said
Yeah, I know.
that.
That was really a joke, guys. I'm also an instructor here. I oversee the Indian law program, and I'm here tonight because my friend saw John's commercial and he thinks he wants to be a lawyer. So I'll let him introduce himself.
Somebody saw it.
Yeah, I see it all the time.
Paul, I think you were John's first commercial. So, my name's Andy Fraga, and actually a musician by trade, but Paul had been raving about this, and I've always been interested in law. One of my best friends, I watched him pull himself up with no help, and he went to Pepperdine and did great. And we recently lost my stepmother through cancer and everything, but I had to be her advocate and fight a lot of medical insurance stuff and all of that. And Paul, along with my friend I had grown up with, were kind of inspiring on how to deal with that and really tipped the scales in our favor for everything. So, different point in my life, a little kid to raise, moving my drums it's a little tiresome. So, Paul was gracious enough to bring me down. So.
Yeah, well, we can always use drum analogies here. So I want you guys to know, this is sort of what I tell everybody, the ground rules are you're watching, okay? So these people are participating and you're watching. I tell you that because we had this one guy come and he has about 500 questions and I almost had to punch him out.
And I sat here thinking, how long is John going to let this go
Yeah,
on?
finally.
Looking at him, I said, John.
No. So, but I'm so happy to have you here because anytime anybody's a potential new student. So let me just tell you guys something you probably at least got a little peek on when you came to the Friends of Family. Dean Stedding has like been a prosecutor here for 35 years before you retired. And was basically the head dog here in the office for the last 20 out of the 35 years? Princess. But I mean, and she really, really, really knows how to give some practical advice to you when you see a crime. And I'm on the defense side, and I've been doing it since 1978, so 41 years. We want to give you two things out of this class. We want to get the basics so that you understand what you have to do to take the baby bar and eventually the California bar. And the basics are different than the real world, but you got to pass the basics in order to get out in the real world. And we want to also give you real world examples and insights that we see, because it's one thing to study assault or battery or whatever you want. It's another thing to actually know what these things look like in the courtroom, and you will have experience in this, Charlie, where you see things that are a little bit different. Literally, the rule statements that we give you that we will eventually work with, and I should say parenthetically, I'll be working with you on Saturdays on that, more of the prepare for the exam, get the memorization stuff down. It's not philosophical, but probably a good choice of words. We want you to understand the concepts. You got to have the rule statements in order to pass the exams, but you have to think when you get out of law school. And so we want to try and cultivate the thinking. That's really the most important thing in the class. The ability to think, the ability to focus your attention on a subject, to look at the elements of a crime and analyze each set of facts and how they might contribute to the elements. Believe it or not, I have some jury instructions here. Eventually, the jury instructions you will see are pretty much a slight variation on the rule statements you're learning right now. But that's at the end when you start practicing out there in the world. So for right now, the best thing to do is just be a blank slate and just follow us week by week by week. And eventually you get to the point where you're pretty good shape to take the baby bar, and then we'll have another month and a half after that to even get you in better shape. And then once you pass that, most of our classes, you know, we talk about practical things, but things like elements don't always apply when you're talking about constitutional law and things like that. It's more philosophy and interesting ideas that are sort of cultivated. We want you to get more than just law school education and get out of here. We want you to have practical. So on Saturdays, we'll not only work on some of the things that are more practical as far as exam, but we'll have somebody come in every week, either a prior student, a judge, somebody who's going to tell you their story, and you can see the people. And you did what most of us did. You know, you look at the other guys in court and you go, wow, I can do this. Because it's in a way embarrassing how bad the general population of lawyers is in the courthouse. I have to say, don't ever repeat that. But there's some really great lawyers, fantastic lawyers, and you can tell when you watch a preparation, as you mentioned, very important. And then there's a lot of people that we could easily replace because they're just not working too hard, or they're doing whatever they're doing, drinking on the weekend, or maybe in the middle of lunchtime or something.
And then there's a whole young group.
There's a young group coming
Process
up.
of being trained.
Well, yeah, and I was judge was just mentioning they have a trial over in Bandy, and there's this judge whose father is an appellate justice now. And he just had like 3 trials in a row with young lawyers who were doing DUIs and stuff like that. They said, oh my God, all they do is just annoy each other. And eventually you get the point, and hopefully I want you guys to get it sooner than later. It's the issues that you are having controversy over or having a difference of opinion on. It's not the people. And so nanny nana is not really good trial lawyer work. But there's a lot of it out there. So we're going to try and give you practical ideas and practical insights, but we're going to teach you the basics so that you can pass the exams, because nobody can be a lawyer if you don't pass the exam. And then hopefully the speakers in here are going to give you a connection to the legal community. Between San Bernardino, Riverside, Imperial County, there's a body of lawyers out here that are handling all kinds of cases. Obviously, I'm involved in criminal cases, but there's all kinds of civil cases and all kinds of things going on. And the more people you know that are in that, the more you can approach and become part of the fabric of the legal community out here. Unless anybody plans on leaving between the desert areas, we're lucky. We have lots of people out there, but lots of room for really good lawyers. So our intent is to see if we can't lead you along. You'll start out being spoon-fed. You'll end up being very independent, not wanting to be here, wanting to take the bar exam, get out of here, because that's what happens at the end. But we want to take you through the process, and we're here. I think our email and everything is on the syllabus. You can call us anytime. You can bring up any questions you want. There's no dumb questions until right before you take the baby bar, and then we'll tell you to really go. Otherwise, you're good. And I know that Dean Steady is just so good about being generous with their time. And same thing, you got my cell phone number, you got my email, whatever you want. We'll just keep working on it until you guys get this stuff down. My job is to be sort of pushing you along. I'm more the practical guy, and Dean Steady is more the thinking part of the game, and the two together can really make a difference. So let us move on.
So having been called a thinker, I now have 3 practical things to point out to you.
Excellent. Good cross-reference.
Did anybody, when you open the textbook, actually read through the table of contents? I'm just curious, because law books have pretty thorough tables of contents. I will tell you that there will become a time during the year where your head is spinning and you can't figure out up from down. That happened to my son, who is a recent law graduate, and he called me on the eve of an exam where he was feeling totally behind, absolute panic. My job on the phone is to unpanic him, and I said in the subject, go back to the textbook and go through the table of contents and say, oh, I know that. Oh, I got that. And it will help calm you down and remind you that maybe you really do know what's going on, just as a tip. The other tip I learned from a former contracts teacher here, I thought it was humorous at the moment until I realized what she was talking about. At the head of every page, it reminds you, flip over, just turn somewhere 154, for example, is where I'm at. At the top of the page, it says mens rea. And there's a case there. You're in the process of briefing. People versus Paul starts on page 153 and concludes, 157. And you're reading through that case going, what in heaven's name am I supposed to get out of this case? And you say to yourself, oh, I'm in the topic of mens rea. I need to be looking at the mental intent, the intent for the crime. That's why this case is here. So it's just a tip to settle you down and put things into perspective. And then I wanted to talk about what does it mean to brief a case? What does that mean? It's lawyer talk. A brief is typically a written document of many, many pages that sets forth issue, rule, or statement of facts, statement of law, facts, and conclusion. And it's usually written for the purpose of impressing a judge to go your way on a particular topic. But for all of your essay writing, your midterms, your finals, and your baby bar, and your bar exam, you're going to use the IRAC format. Issue, rule, A for analysis, which includes facts, so he wrote facts and analysis, and then your conclusion. And I'll give you a tip right now, your conclusion is going to match your issue for essay writing in test situations. And you're going to find your issue when you read the question, because the question will conclude with, in criminal law, with what charges could Joe be charged? With what crimes could Joe be charged? That's the issue. What crimes can Joe be charged? And then you'll do your rule statement, you'll look through the facts, you'll find a crime, potential crime, you'll define that crime, and Joe will be charged with theft. Define theft, regurgitate the facts that are pertinent to each and every element of the fact, and conclude. Therefore, Joe could or could not be charged with the crime of theft. So it's really very simple. When I say it, it's very difficult in application, which is why you will spend a lot of time on Saturdays preparing. And that's what you do for essay writing. When you come here to class, my preference when you brief a case is you first identify the issue. And it's not going to be at the end of the case that you read in the book with a question posed and what could you be charged with. The issue is going to be somewhere in the reading that will identify why in heaven's name is this case being considered by the Court of Appeals or the Supreme Court. What is it about this case that caused it to get to the appellate court process? And some judges writing appellate court opinions will start with the first paragraph. The issue in this case is, but others are not that clear. So you look for the issue, and literally, I write I next to the issue in the margin of the book, so that when we get into a discussion and I'm thinking, where in heaven's name did I find the issue? I go right to that and I see I. And then I'm interested in knowing procedurally where this case is at. What happened procedurally? What are the facts? The procedural facts would be the defendant appearing in this appellate court decision was arrested, he was charged, he went to jury trial, he lost, and the case is now on appeal discussing the particular issue. That's procedural facts. Some cases are pre-conviction, so you want to be able to observe that as you read the case. Maybe it's gone up on appeal on some issue pre-conviction. Those are rare, but they do exist. And then I want you, you are standing and you are briefing the case because I called on you. I want you to tell us the facts that are relevant to the issue. So if the issue is, what does taking mean in the context of theft? I don't really need to hear from you anything else about the theft except the facts related to the issue of taking, if that's the issue. And the courts will do some analysis for you. They'll give you a rule. The definition of taking is X, that's your rule. And you want to have that under control before you come to class. And then there will be a holding. What did the court on appeal do with this case? After they identified the issue, they looked at the relevant facts, they figured out what rule applied, they announced what rule applied, and the holding is the consequences to this defendant based on their decision. Does that mean the case was reversed on appeal? Does that mean the case was affirmed on appeal? Does that mean the case was sent back for further consideration? That's just simply what a holding is. So when you get ready to brief a case, you write in the margins so you're prepared to discuss it, because I'll tell you, when you stand up, all of the blood leaves your head. Your brain is not syncing, and so you need to have the appropriate notes or the case book documented so that you feel more comfortable and encourage that blood to go back to your brain so you can think. Issue, procedural facts, facts related to the issue of the crime. What is the analysis and the rule, the resulting rule, and what's the holding? Somewhat similar to what you see on the board, but that helps. So the first case could be People versus Hall. This is an appellate court case out of the state of Iowa. That's part of the procedural facts. The defendant was arrested. He was convicted of X. It's on appeal for the following issue. The court reviewed these significant relevant facts, came up with this rule statement, which will apply to these facts, and this holding. That's basically it. Yes, ma'am.
So to clarify, okay, so what's on the board is what we're going to use on like tests for essays and stuff, but for class, we should include the what, holding and procedural history?
For briefing a case,
Yes.
not for writing this.
Okay.
That's
So-
what I'm trying to distinguish them.
Right. And I want you guys to get this. This is the pattern that you use to answer legal essay questions, okay? So it'll take a while for you to get this, but I want you to know that every question has to be in this order where the reader from the bar or wherever can see that you get the issue. So you have to identify the issue. So the facts say that Bob Jones was walking down the street and he saw Bill Smith, and Bill Smith had threatened him before and was sticking his hand in his pocket, and he thought that he might be pulling out a knife, so Bob decided to pull out his gun and shoot them. So what's the issue? Murder, right? Somebody just got killed by somebody else, right? And we'll give you the definition of all that, okay? So that's the first thing. And
That's
we're
your
gonna,
essay writing.
and this is essay writing again. We'll narrow things down to not just what could Bob be charged with. That'll be at the call of the question at the bottom. But you're going to find one word or two: murder, burglary, assault, arson, whatever. That's going to be what you're talking about in this particular area of the exam. You might have 5 issues in the exam, so you need to write one of these for each one of them. Okay, so usually it's one word, and we'll talk about how you want to be economical with your time and all that. Sometimes it's 2 words. Then the rule statement. So murder is defined as the killing of a human being with malice aforethought. So now there's 2 things. It's killing and malice aforethought. So you have an act and you have a mental aspect to it, all right? Then you're going to take those 2 elements and you're going to say, do we have a fact that supports an element, or do we have an element that needs to have a fact? It's the same thing. The facts indicate that Bob shot Jim with his .44 weapon and Jim died. That's a fact. that appears to be supportive of a killing. Okay, so there's a fact and a killing. Or you could say murder requires a killing. The facts indicate that Bob shot Jim. So you see, you could do it either way. And then what's next? Did he have malice aforethought? So you might say, no, he didn't. It was self-defense because he was afraid of the guy from the other time, or not. But what I'm getting you is, this is so simple that it's really hard to do, which is all you got to do is identify the issue. And that's hard sometimes, because sometimes they get a little subtle in what you can see in the question. And then you just have to say a rule statement. And we'll have these rule statements down so you guys don't have to think about it. It's the only memorization you have to do in law school. What are rule statements? And we'll get those all down. Then you're going to go for how many elements there are. There's at least one fact, maybe two sometimes, right? And then you're going to have a conclusion. What do you think is the least important part of this? Conclusion. Nobody cares. This is totally different than most educational things where you're supposed to figure out the answer. This is like math. You show your work. We really care. I can't say we don't care about the answer as if it's completely stupid that we're going to say something about it. But if you decide, well, these facts tell me that because Bob had a reasonable fear that Jim was going to shoot him, even though he was only grabbing for a knife, Bob assumed and acted on that and shot him, then you might have a self-defense, right? Or you might say, hey, you don't shoot a guy 20 yards down the road because you think he might be coming to attack you. Well, then there's no self-defense, and we'll talk about the details of that. We don't really care about the conclusion nearly as much as can you show us you found the issue, you can tell us what the rule is about that issue, you can manipulate the facts, or I call it factual analysis. I suppose analyze the facts would make it a little bit easier. This is the IRAC. So in class, we're going to be working on extra stuff, procedural history, the holding of the court and all that. For purposes of essays, we narrow that down, just IRAC. And it gets a little more complicated than that, not much more. And literally, it is harder to be simple than it is to not be. It really takes work to simplify what you're looking at. But when you see essays, eventually when you see a legal essay, you might see 4 paragraphs and there might be 6 crimes in there. So each one of those crimes has to have another IRAC. Murder, arson, burglary, robbery. And each one then you have to go through this process, and it just takes a sort of a linear approach to do this. And it's so hard because there's all this stuff swirling around in your head. And it's really hard to organize yourself. And one other thing I'll tell you, essays are generally about an hour each. That's the way the bar does it on the big bar and the big bar. So we tell you you should be done in 55 minutes. And we also tell you should spend at least 15 minutes, maybe 20 minutes, outlining your answer before you write. People with laptops just go off the edge. They just start writing right away and they get lost on where they are, and all of a sudden there's all this stuff. And it's not simple. You want to be really simple. And when you're really simple, you can write an essay in 40 minutes, 35 minutes easily. But you have to be organized because you have to know where you're going. What am I going to do first? What am I going to do next? What am I going to do next? So we'll talk about that. But I just wanted you to see, this is more of the practical side of writing essays. But you can't really do that until you sort of understand what all these crimes are about and what all the elements of the crimes are all about. So that's what we'll talk about during the week. And then on the weekend, we'll work on the writing stuff, okay?
So just to then shift it back to the criminal law class, what Dean Dolan just talked about is essay writing, and this is what the school suggests will be more successful on the baby bar and the bar exam. In this class, when you come in prepared to tell everybody what you learned from the case book, specifically the problems and the cases that we read, follow the issue, the facts, the procedural facts, the analysis, the rule, and the holding. And let me just, you head towards last night. I'm sure between Judge Evans and Sam Trussell, they have their own way that they want you to be briefing cases. If they didn't spell it out last night, you will figure it out. It probably is not the same as what criminal law wants. In contracts, perhaps not as well in their textbook. So feel free to be as flexible as you can. Just keep track of what professors prefer. So
Yes.
Smart.
Or to say that another way, do what your teacher tells you in your class, and on Saturday we'll tell you what you do to pass the exam, okay? So if your teacher wants something, if your professor wants something different than whatever we both talked about tonight, well, do what they want, because they have a reason for telling you what they want and why they want it. But eventually we're gonna boil everything down to how can we get you past this exam after your first year, how can we get you past the final exam? The big bar. And the big bar, you'll eventually take a bar review course, and you'll find out things in the bar review course you didn't even learn in law school. So just be prepared. It takes a while, but it is focused, clear thinking that we're looking for.
So you all had torts last night, and you've all read the first 50 pages of the criminal law textbook. What's the difference between a tort and a crime?
I think tort.
Up, stand up, please.
Sorry.
Thank you.
Well, I just came up with two words. I think tort was like an offense on the individual, and then crime was like an offense on society. That's kind of like what
That's very generally and not bad at all. So
Very
tort is civil, criminal is criminal. A tort case will list the plaintiff's name or corporation versus the person who was hurt. The person who was hurt versus the person who hurt them. And in a criminal case, what does the title of the case look like? Yes, Melanie?
It's the state or the government. It's the
State or government.
versus the person being accused.
That's correct. So the defendant is the listed versus the versus listed, and the plaintiff is always the government. So in the state of California, the case reads the people versus so-and-so. In other states, it may say the state of Iowa versus so-and-so. We don't say state of California, we say the people of the state of California.
Or the Commonwealth of Massachusetts.
Commonwealth of Massachusetts, the state of X versus an individual. There can be criminal cases that are the people of the state of California versus an entity, a business, a corporation. They're very, very, very rare, but that it can exist. So the big picture here is going to be comparing to torts is basically how the case is structured, who the worthy opponents are.
And one other way to look at this is jail. Torts, no jail. Crimes, potential jail. Okay, you get that?
Torts.
Punishment for
Torts.
crime. Money.
Criminal.
Money,
No
punishment. And it's personal punishment versus money. It helps you to start seeing this kind of stuff, because you'll get a little confused, because some definitions are very similar. Assault, battery, false imprisonment, those kinds of things. And they're stated slightly differently between criminal law and tort law. And we'll make sure that you get that. But you need to understand, tort is a civil wrong, and criminal law is a societal wrong. Look at it that way, right? I don't mean to put too fine a point on this, but we actually got together, everybody in California, everybody in Massachusetts, or if you had the federal government, what would it be? The United States of America versus, Chapo or whatever. And we said, we're going to live by a set of rules here, and if you violate the rules, there's going to be consequences. So in California, we have a penal code. I think it was 1872 or something like that, that we started putting together a penal code, and it's grown over time. So while we will study cases, those cases are to illustrate certain kinds of criminal offenses. They usually grow out of the penal code as far as the court is concerned, but they have a background of the common law. And from England to here to how it's developed over the years, you have the background of the common law. So we're going to learn common law here. And we're going to study cases that have sometimes state penal code sections, but the common law is what we're looking for in teaching you how crimes work and what elements crimes have. And things like, it's so confusing. In California, you have, we just call it assault with a deadly weapon, but that's really assault and battery in the common law. Because, if you shoot somebody, with a deadly weapon, you can have a 245, which is an assault and a battery. We're not gonna worry about that. We're just gonna worry about what is assault, what is a battery. And then when you learn all that stuff, you'll see how it sort of comes together when different states or the federal government, for that matter, put stuff together. But just remember, crimes are against the rules of society, or a conduct that's contrary to the rules of society. And torts are usually people, but sometimes companies, and it's about money. And there's nothing wrong with that, by the way, it's just they're different. Okay? You don't want to be writing tort stuff in criminal law or criminal stuff in torts law. Your professors will not like that. So we'll help you distinguish as time goes along.
So the first 30 pages of the textbook that you read is more setting the stage and giving you a perspective of what is a criminal case, how did we get there, what are the players involved, none of which you will be tested on. There are a couple of things in the first 30 pages that I will say, remember that, write that down, you're gonna need that later. And when we get to that, I will tell you to do that. But the first 30 pages, there were no cases to read, no problems to solve, nothing for us to discuss in any criminal law student professor type way. But we are going to run through it because it's a very good briefing of the criminal justice system. And it starts with what is the government's role? The government, of course, is the state of California. The representative of the government in a criminal case is the district attorney's office. And in California, we're divided into various counties. So here, it's the Riverside County District Attorney's Office, represents the people of the state of California. For Charlie, it's San Bernardino County District Attorney's Office. The government's role is to address criminal conduct. And so how do they do that? Well, figure out if the conduct violated social norms, if it violated prescribed laws. Does it interfere with peace, safety, and the order of the community? That's what we're playing with in criminal law. And from those basic, not quite philosophical comments, more practical than philosophical, but from those very basics comes this issue of discernment. Well, when does a prosecutor decide they're going to file a criminal case against somebody? How does the judge decide what appropriate punishment it would be for this particular crime? What does the statute instruct the judge, and what does the case law instruct the judge? And really, with all of that, what are we as a community intending to do with the outcome of criminal conduct? So that's really what is involved in government. Generally begins the show and then becomes part of the act, along with the bench officer and the defense attorney representing the client. How is criminal conduct addressed? They talk in terms of punishment and social stigma. I don't know what people would consider social stigma, because we're not putting anybody in locks in public places anymore, where they get to have a big sign around their neck saying this is a bad person because, but there's some social stigma being on probation or being in jail, and there's also a significant level of punishment to that. We classify crimes in the United States based on principles of proportionality. What is more serious criminal conduct? What is not so serious criminal conduct? And so what do we call those crimes that we consider serious criminal conduct? Anybody, go ahead. Felonies. What do we call those crimes that are not so serious criminal? Yes. Misdemeanor. And how can you tell that by looking at a legal definition that it's a felony or a misdemeanor? Because we're not going to use any individual's idea of what is serious, because that would be a bit chaotic. But Melvin, how do we tell what's a felony and what's not?
Well, by looking at the length of punishment, well, over a year would be only under a year. Right, and yes, that's generally true. If it's over a year in custody,
It used to be over a year in custody and the custody was in state prison, but California changed that a little bit. We have felons who are doing local custody in jails for longer than a year. Longer than a year is the key. 1 day less than a year is the maximum punishment on crimes that are misdemeanors. And then we have the third kind of crime are the regulatory or the traffic infraction type crimes. Those that are criminal in nature, and they are the people of the state of California versus the driver who went speeding through the intersection. That's exactly what the ticket is all about. But there's no jail available for traffic infractions or any other kind of infraction. Now, some folks may have a friend who went to jail from a speeding ticket, and the prosecutor or any attorney, and you like next week because you had class tonight, will know that that's not possible. So your brain says, well, then how did he go to jail off of a speeding ticket? Well, because when he first went to court, he was ordered to pay a fine, but he hasn't paid the fine, and so his failure to pay a fine, failure to show up in court is a misdemeanor. So he's going to jail for the failures, not for the speeding ticket itself, but the post-conviction failures to comply with court orders.
Or the pre-failures if you don't show up in the first place.
Well, then you get booked in jail on an outstanding warrant. You may not stay there very long if it's the warrant is for an underlying traffic ticket. There are different kinds of prosecuting entities. Riverside County District Attorney's Office prosecutes all misdemeanors and felonies that occur within the jurisdiction of the County of Riverside. In Los Angeles, for example, the County of Los Angeles, the district attorney for the County of Los Angeles prosecutes all felonies. They don't come anywhere near misdemeanors in Los Angeles. There is a city attorney's office that handles the misdemeanors in the County of Los Angeles. That's just a difference between two counties, primarily based on population and resources. There are some crimes in Riverside County where city attorneys will enforce city ordinance violations, which are criminal, but they're more infraction-like because they don't carry any custodial time and they are handled by the city attorney's office. And they go into the criminal justice system. So on occasion in any given courtroom, there's a city attorney there waiting to prosecute a particular person for a violation of a city ordinance. May have something to do with an open beer container, may have something to do with an unkept lot, maybe something to do with failure to eradicate a nuisance that's reached some kind of criminal ordinance violation. So in that context then, where do police officers fit? How do they fit into the story of criminal cases? Who are they? How do they fit? Anybody know?
From what I remember reading is they gather all the evidence when a crime occurs.
They're the first responders. Who do you call when you find your TV and your back door broken? You call your local police department. You call your prosecutors.
What are the three branches of government? Everybody remember this from 8th grade? Executive branch, legislative branch, judicial branch. The courts are the judicial branch. The legislative branch is a legislature who passes the laws and makes crimes. And the executive branch includes law enforcement and prosecutors from the district attorney or the attorney general. So you just got to know where everybody fits, okay? Simple stuff, but if you don't get that, it helps you sort of get a perspective.
Okay, so let's talk about discretion. Do you think law enforcement has any discretion on whether or not they're going to arrest or pursue criminal charges? I've seen a bunch of maybe yeses, maybe. Yes, they do. They can exercise some discretion on the street. They can exercise discretion to book or not. The district attorney's office is happy if they don't book until they've finished investigating the crime, because there's a different time frame involved. So Do prosecutors have discretion regarding whether or not they're going to pursue criminal charges? Definitely, yes. And what variables would you hope the prosecutor is using to exercise that discretion? So go ahead, Melvin, Stem.
The amount of evidence, I like if it's a provable case or not.
Right,
Evidence matters.
right. Where do you think we learn the evidence? From whom do we learn the evidence?
It's from the police.
From the police department. They've written the reports, we read the reports. If we don't see the same thing they did, we exercise our discretion and reject the findings. That's right. What other variables? Can't prove it is a good one. Yes, you.
Seriousness of the crime. You would hope that the more seriously get prosecuted in
Okay.
places some of the lesser offenses, right?
Okay, so you brought up, yes, yes, the answer is you brought up an interesting question. If the crime is not that serious and the alleged perpetrator is young, rehabilitable, if you can watch me make up a word right now, should the prosecutor exercise discretion? Deputy GA, been with the office a couple of years. I'm looking at this case, it looks pretty Mickey Mouse to me. It looks like this is a nice young man. In fact, John Dolan has sent a letter in to ask the prosecutor to look twice before filing the case because he has some good things to say that may be of interest to the prosecutor. Is that something that should be done, or should everything be filed and let the criminal justice system sort it out? What do you think? Yes, Phoebe?
Well, is there time for everything? Time and resources for everything to be filed?
So you've now raised the question of time and resources.
Yeah.
There's absolutely not enough time and resources for everything to be filed. Absolutely not. Yes, sir.
Okay. This is a philosophy question. In theory, they shouldn't be able to do that because in my experience with my kids, it wasn't until the prosecutors realized that they had a parent with resources that they allowed for alternative methods of punishment to be allotted. I'll say no.
Okay, so since you're in juvenile court, meaning the petition was filed,
Yeah.
charges were brought.
Right.
And then the prosecutor realized that there was a parent wanting to parent appropriately who had resources, and then what happened?
Well, in the case of my son, they filed felony charges. He was 14 at the time. I wasn't his legal guardian at that point. I got involved because I knew the family from church. And so what we ended up working out is that they would reduce the charges to misdemeanors, put him on probation, and then I would assume legal guardianship of him. And he would move here to California with me because he was in a different state. But had I not interceded or had my lawyer call and intercede there, they wanted to incarcerate him.
Okay, so the way you framed that suggested to me that you thought money talked.
In that situation.
Okay, so let
Or at
me,
least relationship.
okay, so let me rephrase that. It may have been, because charges had been filed, some prosecutor had decided a crime had been committed and this young man, right, 14-year-old?
Yeah, 14.
This young man did the crime.
Sure.
And we're going to hold him accountable for the crime. In California juvenile justice system, and I don't know about the other state, the goal in the juvenile justice system is to rehabilitate, not to punish. Now, in the adult system, there's some broader variables. But in the juvenile justice system, we rehabilitate. How do you better rehabilitate a kid, but find resources that are available to the kid that will help him learn better? You became one of those resources, not because you had the money, but because you had the interest. Okay?
But my question is having the access, because there's a lot of people that have the interest, but they don't have the access. And so
Right.
for me to get the access to that person, it required a relationship there that a lot of people who might have the interest do. And so that's where I would say maybe the money talks kind of.
Actually, it's all about your interest. Now, the fact that you were able to make your way into the system is it's positive, not remarkable, and not because you have money. People figure out how to do that. The young man had a lawyer. That man's lawyer is looking around for resources, and up you pop. So you're essentially helping his lawyer do the best possible job. So I'm trying to dissuade you from thinking money talks. Reality is, I'm sure it does, but in the juvenile justice system, they're looking for rehab. And if they can find resources, not financial resources, but people who will take control of this young man and set him on a better path in life, the court's going to exercise its discretion and judgment and make that happen. Now, how you make that happen is through what we call plea negotiation. We'll reduce the felony if you will admit the misdemeanor, young man, and you accept these following conditions. You are going to go with Melvin to wherever he lives, and Melvin's going to help you report into the probation department, and Melvin's going to help you stay on the straight and narrow. And if you goof up, young man, you're going to be back to court. And they transfer the whole probation to Indio or wherever you live. So if he ends up being back in court, there's a Riverside County probation officer watching out for him, and you'd end up back in Indio juvenile court to account for his. But that's absolutely not uncommon. So that was a good diversion.
Well, there's one little twist on it. Forget juvenile court for a minute. When the question is, what discretion can be exercised? If you've got a weak case, there are some crimes called wobblers. I don't even know where that comes from, but it could be a felony, it could be a misdemeanor. District attorney decides if it's going to be filed as a felony or a misdemeanor. That means you're exposed to prison, you're exposed to nothing more than a year in the county jail. That decision is usually made by the prosecutors on the basis of the kind of things we're just talking about. This kid has no record, there's sort of a story behind it, it doesn't look like it's going anywhere, weren't serious injuries, whatever. And so they will say, well, we're just going to file this as a misdemeanor, even though he's arrested as a felony. Classic example right now in this world is domestic violence. Domestic violence will always be a $50,000 bail. It will always be a felony arrest. If it is a scratch or something minor, somebody twisted my arm or whatever, they'll read it and they go, we're filing this as a misdemeanor, it's not a felony. You got teeth knocked out, you got broken bones, you're going to have a felony. But they don't distinguish these days because of there's a lot of historical background.
And legislative.
Yeah, and so you're going to put a $50,000 bail, whether it's a misdemeanor or a felony, assuming you put a bail. And then it might be that it's filed as a misdemeanor. And that discretion is in the hands of the prosecutor. And they are routinely very good about, cases that really don't belong to be felonies or not felonies. Now, if you got a guy that's got 10 strikes, and here we go with another problem, they might look at that and say, we're going to file this as a felony, even though, on this case alone, it might not be a felony, but in this instance,
with the criminal history.
Yeah, with the criminal history. So that's a really important thing to know about the discretion. That's why we're writing letters to the DA. We're talking to them on the phone saying, hey, really look at this, because I know this maybe when you first read the report, but if you really get it, this should be a misdemeanor rather than a felony. And they'll listen. You got to get to them before they sign the thing, because once the thing is signed, it takes all the life it's on. But it does. But it's really important to know that there's very major discretion on the part of the district attorney about what to charge. And you could charge an attempted murder, or you could charge assault with a deadly weapon, or you could charge a simple assault from the same facts, depending on circumstances that surround it. So that's really an important part of discretion.
So one last part in the book, they gave you a number of different entities that had discretion, including probation, release clerks, bondsmen, jailers, etc. There were two terms before we get too far into this: malum in se, M-A-L-U-M in se. You want to remember those. You want to remember malum prohibitum. Does anybody remember right now what the definition of malum in se is? Yes, sir. Great.
Philosophy.
Yeah.
Philosophy guy. Or at least know a little Latin.
Did you have Latin?
Not too much.
Really?
Malum in se would be inherently immoral, and roundabout would be criminal by legislation.
That's exactly correct. So malum in se, can you think of what crimes might fall within malum and se?
Well, you say.
Immoral and evil.
Yeah, the statement you made before with societal notions, I mean, it can be, I guess, a little philosophical, but we like to think that there are sort of norms that we all agree upon, or like we don't want people to be able to murder or.
Murder is an example.
Other ones are maybe a little more fluid, like spitting on flowers or something. That might not.
That is not
Yeah,
malum
that
and
might
se.
not be anything like that, or something else. Yeah, there's.
So you have murder, what else would you have as a malum and se?
These very simple ones, if you imagine, like Old Testament style, like these are things that are
Ten Commandments, think about that. Oh.
Yeah, the obelisk on the wall of the whole village kind of thing.
Right. So malum and se is almost equivalent to what at common law were considered criminal behavior. So it's going to be murder, burglary, residential burglary, theft generally, rape, robbery, kidnapping. Those are basically your malum and se. And all the other crimes are legislative. The legislators have gotten together and said this shall be a crime. Well, assault is a common law crime. Battery is statutory, or is it common law? Assault, battery are both common law as well.
We mush them together in penal code section. So here's the difference. Murder, malum and se. Dope, malum prohibit. Why is that?
Possession of illegal contraband.
Marijuana.
Selling.
There's people that were in prison for marijuana, and now it's completely legal to go around smoking marijuana all the time. It's because the government decided to make it a crime and then decided to make it not a crime. That's separate from, there's no government that's going to say killing someone is not a crime, right? Stealing someone's property, always going to be a crime, right? Sneaking into someone's house to steal stuff, going to be a crime. Malum and se, malum prohibit. So it's pretty easy to get that stuff. Almost everything, I should say, a lot of what we have in the penal code is just malum prohibit. It's illegal as we say it's illegal. And then there's the basics where we all know it's a bad thing to do. So that helps you to start distinguishing some of those things.
So your source of criminal law, we've moved right into common law, and here I have them listed right out of the textbook. Coming out of England, from which we base almost every state bases their law. Of English common law, murder, rape, robbery, arson, mayhem, larceny, burglary, kidnapping, and assault. Major crimes. Except assault in the state of California is misdemeanor, and larceny, depending on the value of the theft, is a misdemeanor or a felony. The burglary under common law refers to residential burglary. It's still only a felony in the state of California. So everything's a felony. There is they give you in the textbook on page 3, in their discussion of elements of a crime, they give you the elements, the definition of theft. That you want to write down. Crime of larceny. Larceny and theft are used interchangeably. Larceny was used at common law, and those are the 5 elements of larceny. So if you go see them there in the book, an element is kind of interchangeable with part. What are the 5 parts of larceny? In the law, we call them elements. So if you read them there, taking, carrying away, personal property of another, they split it into personal property and of another, with intent to deprive the owner of it permanently. So there's 5 elements. Can you tell me which of the elements describe a criminal act? Just the act. What is the act of larceny? Yes, smell it.
Don't you have to have all 5 elements for it to be?
For criminal conduct, yes, but when we look at larceny, which elements define what act is prohibited?
Taking and carrying away.
Taking and carrying away.
Very good.
Which element describes the mental state that has to be part of, yes,
With intent to deprive.
with the intent to deprive permanently. And so if that's the act and that's the mental state, and a crime is defined as a combination of an act and a mental state, then you have a crime. Why do you think we have these words, personal property and of another? They're not act-like and they're not intent-like. But would you have a larceny if you simply had taking and carrying away with the intent to permanently deprive? Who in heaven's name would know what that was, right? That would be a criminal definition. We're trying to distinguish larceny. So you have what this textbook calls antecedent facts, meaning things that are a little bit more descriptive. Personal property of another with the intent to permanently deprive is larceny. And so when we talk about IRAC on the board for your test, when you write larceny, you're going to write all 5 elements. And when you do that FE thing, the E for element and the F for what facts in the story, in the question that you have in front of you, the essay, support taking, carrying away, personal property of another with the intent to permanently deprive. If you go to statutes in most states, that's what you're going to see. It's coming out of common law. And so let's just pause for a moment and say, what do we need the appellate courts for? We know what a theft is. It's the taking and carrying away of the personal property of another with the intent to permanently deprive. Why do you think we have appellate courts? Because there are factual and legal debates. What is personal property? Now, if we ask all of you to define personal property, you probably would have about 7, 8 slightly different definitions. And that's why we have courts of appeal and Supreme Courts. Because the issue comes up in a criminal case that maybe it wasn't personal property. Maybe there wasn't a carrying away. What does carrying away mean? You mean like 5 inches? Is that carrying away? Does it have to be 3 yards? 4 miles? What does carrying away mean? And we have the bench officers to interpret those terms. So when we, as lawyers, try to figure out what we're going to do with a theft case, we need to know what common law, especially for the bar exam, especially for our exams. You need to know what the statute where your practicing law says larceny is, and you need to read all of the cases that the Court of Appeals or the Supreme Court have rendered on the subject. And they actually rendered on elements a decision. Yes?
I know it's gonna sound pretty stupid.
No, nothing sounds stupid.
Well, number 4 says of another, like you said, it breaks down, this doesn't have to be kidnapping, right? Not taking away someone's
No, it's
daughter.
personal property.
Personal property.
Personal property
Body.
of another.
So here,
So it's,
so you're sitting here and somebody walks in this room and there's a diamond ring sitting over there on the bar. And the person walks in and holds it and looks at it, sticks it in their pocket and leaves. And by the time you go out to follow them, they're already gone. Is that a larceny? Well, it depends. Whose property was it?
Carrying away.
What if it was his ring? What if he knew whose ring it was and he was going to take it back to the owner?
okay.
Right? Can you see how each element has to be? Is it a taking if you're going to take somebody back their own property?
I think I just
It's
got,
certainly it's acquiring, but is it a taking with the intent to
This
permanently
is a stealing.
deprive? Right.
I mean, I guess I got confused because it says of other, you know, like,
Yeah.
I feel like that would be.
It has to be,
more-
if it's his, it can't be a larceny because you have to take the property of someone else. You get it? the property of another. You get that part? So it can't be, I picked up my own ring and stuck it in my pocket. It can't be, I picked up the wallet on the ground and it was my wallet and I stuck it back in my pocket, because it's not the property of another, right? So it has to belong to someone else. Now here's where it gets a little complicated. I won't get too far into this. What if somebody abandoned their property? They just said, I'm tired of this Frisbee, I'm throwing it out. I'm leaving. What if you picked it up and took it for yourself? Is that taking the property of another? Not their property anymore, is it? Right? See, this is what happens when we go through appellate cases. Each one of these elements are analyzed with all kinds of factual scenarios so that you can start to figure out, was there a taking? Was there a carrying away? Was it the property of another? Was there an intent to permanently deprive? I forget what the other fifth element was. But do you get that? So when you ask, what's the deal with the property of another? You can't steal your own property, right? It has to be somebody else. So that's so simple, and yet, you know, you can get confused and think, what does that really mean? That's pretty basic, but it takes a while.
So just circling around to kidnapping, which we will study the elements of in the spring, is essentially the taking of another.
Of a person.
Against their will, a particular distance.
By the use of force.
Yes, against their will by the use of force, a particular distance. It's right in there in the elements, but it's totally different from theft.
Okay, so 1, 2, 3, personal property, 4 of another. Does that go back to if you just see a ring and someone abandoned it? And that would be.
Every one of those elements has to be proven in order to prove the crime.
Okay.
So in each element, there may be some alternate explanation. And so that's really what these cases are about. How do you evaluate a larceny? Was there a taking? Was there a carrying away? Was it a property of another? Was there an intent to permanently deprive? All of those things have to be there in order for you to find that there was a larceny. And almost all of them are subject to factual scenarios, you know? So that's going to be the same with every kind of crime that you have. It's subject to factual scenarios. And so sometimes things on their surface look different than they really are once you know more. That's why we have trials. Because somebody comes into court.
That's why we have prosecutors and defense attorneys.
Right.
Because the prosecutor is going to put an emphasis on certain facts as being strong to support and prove one or more of the elements. And the defense may have a different spin on it, as John just demonstrated, but also they're gaining information from an alternate source called their client, who is the defendant. And with that new piece of the puzzle, we'll put a different emphasis on a different way of looking at the evidence, and that's why we advocate our positions.
So just remember, every crime is going to have elements. You want to look at each element and understand, is that there, is it not there? Is it maybe there, maybe not? What are the reasons why it could be there? What are the reasons why it couldn't be there? That's what these appellate cases are all about. And that's all we read is cases that went through an appellate court, so somebody already got convicted. Or something. Sometimes there's a motion that's in one of our cases, but almost always it's somebody's in the jail and they're trying to get out. And so they're saying, I didn't do that. That was my ring. You know, nobody presented that in trial or whatever.
Yes.
Maybe you talked about it already. So the 5 elements have to be proved.
Can't have a crime without all the elements.
There has to be sufficient
So in that
evidence.
particular crime,
So
it's
what's
5
the-
elements.
Okay.
In murder, it's 2 elements. Killing of another with malice aforethought.
Such as depends.
Act, intent, right?
Sufficient proof of each element, which then begs the question, what is sufficient? And
Right.
that's where the lawyers start to argue. Ultimately, the burden of proof rests on the prosecution to prove beyond a reasonable doubt to a moral certainty that he committed the crime. And ultimately, it'll be a trier of fact, the jurors or the judge, who will decide this fact is proven. I believe to the witness, this makes sense to me. I agree with the prosecutor's version, I agree with the defense version. We're advocates, the jury finally decides. So Melvin, you had your hand up at some point in this?
I was, because you were talking about that, then you brought up kidnapping, and then I decided maybe I would be going too far. But like when a minor child is taken, is there ownership of the minor child? Because like,
It's a different crime.
Okay, and that was my question. Would that be
That's
that?
not a larceny.
Okay. That was my question when they're taken to a different country, or?
It's a different crime and it's statutory.
Okay.
And it has to do with, who has custody of whom and when.
You're
Miguel,
gonna do the same
anytime you
shit that's
speak up,
started,
you
by
get
the
a
way.
shout.
Just leave all that stuff out of here and just go one step by step.
Okay, no, I
You got a lot of history in that area. It's like you got a lot of history in the work.
Yeah.
Not gonna help you.
Set that aside.
Okay, I'm
Two
done.
guys to that. Set it aside. One paragraph here, elements of a crime, lesser included offenses. The textbook gives you an example of theft, which is a felony if it's over a certain amount of money in various states. I think the example in the textbook is a felony if it's over 500, and it's a misdemeanor if it's less than 500, $499. And so the prosecutor has to prove the value of the loss. And if they charge a felony, they better be able to prove the loss is over $500. If they fail to prove it's over $500, but it's still clear there's a taking and carrying away of the personal property of another with the intent to commit with the intent to permanently deprive, but they can't prove the value, but they can prove a value. Misdemeanor larceny becomes a lesser included of felony larceny. So I'm going to give you a quick different example, which I think makes more sense. The definition of robbery. So are you looking at your elements for larceny? Robbery is the taking, the carrying away of the personal property of another by force from the person or the person's immediate presence with the intent to permanently deprive. 2 additional elements, now 7. Which is the lesser included offense, robbery or larceny? Larceny is the lesser included because 2 less elements. Yes, sir.
Could you please go over those 2 additional elements again that you just said?
Sure. So you got the 5 on larceny in front of you?
Yeah.
You add through force from the person or the person's immediate presence. It has to be by force. And that's an example of what's the lesser included of another crime. And it makes sense to me because you got 7 elements, and then you have fewer elements. The fewer elements is the lesser included.
He didn't just take the ring, he held a gun on me and took the ring off my finger. Now you got a robbery. He picked up the ring and walked away with it, and it wasn't his. You at least have the potential of larceny. Get the difference?
And the police report says that's exactly what the victim said, so the prosecutor has filed a robbery. But then, through the course of additional investigation, perhaps something the defense is hinted at, or the witness finally takes the stand and begins to equivocate. Well, I didn't feel fear. He really didn't use force on me. That equivocation makes it difficult for the jury to believe there was force. And they will be given an option. One of the jury instructions on a lesser included is theft. And the jury can say, well, I don't think the prosecutor proved force, but they did prove the other 5 elements of theft, so we will render a guilty verdict on theft, the lesser included. That's how it works out. Your job tonight is to make sure you get those elements of larceny, which are spelled out right there for you. That's the definition of larceny. If you can remember robbery as well as an example tonight, but we will be covering robbery and larceny down the road.
So begin your own person outline by writing larceny, underline, and then dash, and then a complete sentence. Larceny is the taking and carrying away of the personal property of another with the intent to permanently deprive. Whatever the 5 elements are. Get that? That's a rule statement.
But to be clear, we're not studying this until chapter 10, right?
Probably, but since you have the definition of larceny and robbery, and whatever definitions you have between now and the midterm, could show up on your midterm, which your midterm will be one essay question in criminal law, one in contracts, one in torts. And then you will have 60 multi-state questions. And those multi-state questions could include something that you need to figure out about larceny, robbery, that you've already learned, even though we haven't gotten to it in the textbook yet. So the next part of these first 30 pages is the model penal code. You can read through that. There's going to be many references to the model penal code throughout the textbook. The model penal code was established after World War II, particularly in response to the Holocaust and things like that. Looking at the greater world view, some American lawyers and judges got together and said, we need to do things better. And they created a model penal code. It has not been accepted by any state in full as the best code in the land. California still has their penal code from 1872. Some legislatures have looked at the model penal code as they draft and change and update their penal codes. And it's tested on the bar exam in the form of the multi-state. And so that's why you're getting some cross-references to the model penal code. You'll see when it also helps in this context, you're gonna learn what mens rea, mental state is all about, what actus reus is all about. As we learn all of the crimes focusing on common law definitions. But when you see how the model penal code in the 1950s decided to define mental state, you're gonna go, wow, that's kind of an interesting way of doing it. Now, how do we define it in common law? And how do they define it in the model penal code? And it helps you learn both of them, in my opinion. The next part of this book is all about the criminal adjudication process. I just wanted to point out the Latin root, JUS, which means law. So you see it right in the middle of that word, adjudication. You also see it in judge, judgment, judicial, interestingly enough, prejudice, jury, perjury, JUS, the root. And it just means the legal process of settling a dispute. And then they walk through everything from law enforcement to arrest, the charging decision, what charge should the prosecutor bring, all of that should be interesting reading. Some of that you'll see again in criminal procedure as a 3L. So just read it just to put everything in context. There's some discussion of prosecution ethics. There's discussion about the appointment of counsel. Discussion about bail hearings, preliminary hearings. Not every state has preliminary hearings. California is very big on preliminary hearings. States on the East Coast, particularly New York, those states that were much closer to the origins of the US Constitution and part of the 13 original states, really don't have preliminary hearings at all. Everything goes to their grand jury. So we have a lot of preliminary hearings. We do have grand jury. You'll learn more about that in criminal law, criminal procedure, sorry, 3L. Arraignments, pretrial proceedings, the discovery process, some of that you're gonna learn in evidence as well. Here, then there's a discussion of trial, and the purpose is to determine guilt. In torts, the purpose is to determine damages and liability. Criminal court, we're determining guilt. Who decides is it? What if it's not unanimous? What is it? What does happen if it's not unanimous? Does it have to be unanimous in a criminal case? By that I mean, do all 12 jurors have to agree? Absolutely. And if one of them disagrees with the other 11, what happens to that criminal case? It's called interesting word. But the result is, refers to the fact that they can't all agree. But procedurally, the court declares a mistrial and the case gets reset for trial. It's not an acquittal, it's not over, they do it again. All of the parties just do it again. The witnesses come back, it's all done, whole new group of 12.
Unless you can convince the judge that there's no need to do it again. Like if it's 11-1 for not guilty,
On a case that was kind of hinky.
yeah, you might get the judge to just say, goodbye. Pretty rare though.
Misdemeanors more frequently than felonies.
Yeah.
There were some legal issues as we moved to pages 20, 22, 25, 26, jury nullification. Presumed innocent. Who says? How do we know? Where does it come from? The defendant is presumed innocent till the contrary is proven. Where does that fundamental principle come from? It's in the Bill of Rights. It's implied by the Fifth Amendment. It's perhaps in the 16th. You might find it in the 14th as well. We talk about where the burden of proof rests, always on the prosecution, except in bigamy, the burden shifts to the bigamist. In affirmative defenses, self-defense, the burden shifts to the defense to prove it was in self-defense. And we'll talk about that when we get to it, but 99% of the time, the burden rests on the prosecution. Level of proof beyond a reasonable doubt to a moral certainty. There's discussion on sentences, discussion on appeals, plea agreements. Before we take the break, because we got 1 minute, we're going to take a 15-minute break. You hear a lot in social colloquy about plea bargaining. Tell me who's responsible for plea bargaining. How is it that a case gets bargained? Yes?
The prosecution.
Prosecution is not solely responsible.
Oh, but they come up with the terms of it,
The
correct? And then the
prosecution-
defense has to agree.
Please stand.
Okay.
He's asking you to stand.
So, I just let me keep talking.
Yeah, I don't know.
I was like,
I have nothing more to say.
but so the prosecution comes up with a plea agreement they would be willing to do, and the defense either agrees to it or doesn't.
Not true.
No.
The prosecution and the defense together come up with
Okay.
agreements.
Okay.
And
If you're a defense lawyer and you're saying, hey, what are you willing to offer me? You're gonna get slapped in the face most of the time. You both have to come together.
Mhm.
And you have conversations
Mhm.
about strengths and weaknesses on both sides.
Mhm.
And then if they both know what they're doing, and that takes a lot,
Mhm.
they'll work it out. The prosecution, you can't have a plea bargain without prosecution.
Right, because they have the ultimate, the last say in
Right.
it, right?
A judge can't
Right.
make a plea bargain for you.
Right.
A judge can sentence you,
Mhm.
but you have to plead guilty to everything.
Mhm.
Maybe you don't want to do that.
Mhm.
And the defense lawyer has to agree to the plea bargain
Mhm.
and believe that it makes sense.
Well, if you don't take the plea and then you're convicted of it, there's no going back and maybe,
It's over.
hey, can I have that plea again?
It's over.
Yeah.
so here is my pet peeve and a social misunderstanding that you should not have said. The prosecution and the defense attorney will sit down and say, we mutually think this case is worth X. It may mean that the prosecution is willing to dismiss a couple of counts or reduce them from felony to misdemeanor. And the defense is willing to say, my guy will plead guilty, but he really doesn't want to go to state prison. Can we get local custody instead? And we can bring our little minds together and agree, and the defendant can be on board. But we have no power to conclude that case through a plea negotiation. Who has that power? That's my point. That's my pet peeve. Alvin, who has the power to settle a case through a plea negotiation?
Okay, well, it would be, the judge can reject it,
Judge can
but
reject
the
it.
person who's the defendant has to agree to it.
Yeah, so my hypothetical was, the reasonable minds of the two lawyers intimately involved in the case have decided this case is worth X. And the defendant's on board with that.
Okay.
He's willing to take X, please, I wanna get out tonight. It doesn't happen unless the judge says, okay. that's a fair settlement of the case. The judge has to exercise some judicial discretion. Now, how do they do it in the dark? They haven't read the police reports. They usually want to know a little bit more about the case. They want to know a little bit more about the defendant, his criminal history, his background. Why do these two lawyers think that that's a fair disposition? How does the judge make sure that she's doing the right thing? And maybe those two lawyers are up to no good. You don't know. But my point is, the entire world acts as if this is all resting with the prosecution. And it's not. There's no plea bargain without judicial proof, ever.
And without the client saying, I'll take it.
Exactly. And 95% of all filed criminal charges are negotiated and plea bargains. 95%, 90%, what do you think? 100%?
Here in Riverside?
You tell me. How many filed criminal cases are resolved through plea negotiations?
I'm not a good source because I only get the life cases.
None of yours,
Yeah,
yes.
none of these. I'm sure, I mean,
90%.
yeah, it used to be 90%. I think it's a little bit less. Although, plea negotiation can be just, hey, plead guilty. Okay, that's a plea bargain. But it's not the same as going to a trial, right? So I would say the better question is how many cases go to trial out of those that are filed, right? That would be another way of looking at it.
Yes.
I would say in felonies, it's a pretty high number in Riverside County that go to trial, although there's a lot of settlements. But I would say in misdemeanors, it's not nearly as high. Because in Riverside County, nobody goes to jail because we don't have any rooms. So there's all kinds of easy ways to settle cases. I mean, literally, in Orange County, you take a second time DUI and somebody takes 90 days, they're going to do jail
Real time.
Over here, it's like put an ankle bracelet on and don't do that anymore, kind of stuff. So it really makes a difference in settling cases. I would say we probably settle more misdemeanors out here than felonies. And I think in Orange County, LA County, they probably settle more felonies than misdemeanors. But they're all, I mean, you can't, the system can't function if everybody goes to trial.
So we're gonna come back at 1:45. Miguel, we've got 7:34 here. We'll be back at 7:45. Please feel free to go out, run around, have whatever's out there snack-wise. Do whatever you need to do, and we'll come back and start with a quick summary of what's left before we do Queen versus Dudley. John can't wait.
The classic case.
Queen versus Dudley.
You'll love it. You'll love it.
Okay, you're great.
All right. So you guys can stay as long as you don't have to stay.
I was just asking. Get into the situation you're in.
Yeah, you want
Just
to
having your children. And where do they live?
Lots of questions. They've all had a different pathway, so.
Okay.
I'll think of the
Well, no,
I wanted you to define it.
14 was the place to work. Knew it could work for you. I've been in this week up stuff. Got to know him and watch him grow up about 10, 11. And 2014, showed up for his job. 3 months after that, he came to me and asked me for more hours. And I was trained for Quest, and I was like, why do you need more hours? And I told us that had a depression, mom had a depression, and so then
Yes, and see, that was it.
stay with me until your dad gets out of jail.
No, I knew it was just an honesty.
We went and got temporary. I called a lawyer. He was a friend of mine. He drew up the temporary.
I'll see you, I'm in on the 24th. I'll see you.
Take care. Like 2 weeks.
But we do have a faculty meeting
Oh,
next Wednesday.
next Tuesday night, okay.
I'm sending out an email.
Okay, yeah, I will
We
be.
tend to bounce back from your
So then,
well, they always did, but now they're calling back Casper.
Okay.
Send rotary emails to them. What's bouncing back is anything with the. That's
So
not
then-
somehow.
He was, did he live on the reservation, or why was he, and his father was Native American?
Tuesday.
Because
So then why, If he wasn't
different than the reports.
full Native
So I
American,
may
why didn't
not-
he go to their
I may
court?
still be on.
Because she was,
Oh,
if you have more than one acre.
I see you.
Okay, they take that
That
day.
part of it, I mean,
Okay.
he gets his payment from
Okay.
the tribe, like he's part of the tribe.
Okay.
And so that's why I got back to the Native American court. So,
Okay, interesting.
again, it was crazy, but I did learn how to navigate Native American courts
Yeah, I think that was gonna be a super interesting class.
pretty well, and according to their guardian ad litem, I was the first case where she ever seen a Native child who awarded care guardianship to a non-Native
Yeah, I would imagine they don't
who
want
has
to
no biological
do
relationship.
that very
They don't.
often. Yeah.
I mean, I didn't know the process. I had to go in there and prove everything that I had was on display, my financials, my reputation, and then I had to also show the means by which I was going to keep them connected to. And
Yeah, sure.
But we proceeded to do that. Went through high school. I brought all my other kids because I had transitioned from public high school to private high school.
Okay.
And they had a large contingent of exchange students. And so you came really close to two that are a year older in freshman year. And so he asked me, hey, can we get one exchange student? These kids are coming for like 6 months a year. They're coming for all of their years of high school. And so I said, yeah, sure, I'll try. We can get a foreign exchange student. Somehow over the summer that changed, well, it changed from 1 to 3. And so it was then being parenting 4 kids. And then there were some issues that was happening systematically at school that I pressed them on. And so then that displaced 2 more experienced students also again.
Oh, yeah, I was gonna ask her there.
And so then it ended up being me, Jamal, and the 5 Serbians.
Serbians speak what, Russian? They speak Serbian their own language?
Serbian.
Okay, how
But jokes,
you learn pretty quickly.
Like we're still very connected. Like they, like one of them is here in the desert, California with us. 2 of them went to college in the States, and I was primary parent, all the way from freshman year high school all the way through. So they're very connected to us. I always make the joke that we were like the gay, the black guy Serbians, because we're the only people that can handle each other. Because of the
yeah, I wanna be real quick as
Then, let's see, they all graduated high school. I was like, I'm going back to my normal life. But then, after 5 years of therapy,
hey, Michael, how are you? So I just got your text. I mean, I just saw it.
How you doing? Good.
Good, thank you. How are you doing?
Good. Enjoying it. Yeah. Just a little nervous.
Of course, of course. Pretty soon you're gonna be really nervous. And then you're gonna be all mixed up in your head.
So,
Takes about, hey, AJ.
Then you're gonna get your real property loan. You'll be super confused.
It's gonna do well.
Okay.
But it takes about the first semester of law school to begin to think, okay, I need to do it this way, I need to completely shift my thinking process.
Hey,
And you'll figure out, welcome, you might be a little ahead of the game when you start reading assaults.
Did you get my notation on correcting the, okay, I asked them to email you to call me.
Telling your family members.
Go over the.
I didn't even look at email today.
No, it was from last week.
Oh, wow. I'll have to check my trash because I didn't.
That's what it feels like.
If you wanna call me tomorrow, we can go over it.
Okay.
I really like the lady that was, yeah, so I kind of grasp that, 'cause I know exactly the procedure.
With the Indio system, I can't open an order unless I order it, or unless I pay for it.
Okay, call me, because I just wanna give you the detail, because the whole reason that
Yes, I
you're seeing
agree.
the client and the attorney is because he's like, I signed this up 2 weeks ago.
I think
Oh, yeah.
So I'll just like,
I'm getting
so
the.
basically whoever's just needs to say that he appeared and something like this, and that's the thing.
And the LIL, the lesser included offense, that was great. I didn't think that was, okay, so that would click. Yeah, okay, so wants to be robbery. I see.
I'm so sorry. But the guy represented all of our
We call it, like, you know, the acronym is LIL. So that can.
And I said,
But,
that makes sense why he didn't, because he was not only using the record, but it's professional courtesy. So that's what he wants to keep.
My mother, she was very impressive.
Did she come to friends?
She did, yeah, she did.
Right.
I'll sign it and then you guys can send it out.
Okay.
So thank you.
Are you teaching tonight?
I am, I'm gonna go back in and see.
Sorry, thank you. I didn't get it early though.
One of these days, we have time.
Oh, I know.
Yeah.
So he was supposed to look at. We were joking about that earlier.
I remember there was a table.
Maybe also because the first day, I was really good.
I know, I was walking into the glass out there. I was so tired.
You just don't hear me.
I didn't realize he was talking about something. It's like, wait, please. Yes.
So, age?
I said the other day, I just did face, I just went close things.
You're in the room. Not quite.
Just like, you have a message from Irene?
Yeah, she sent us a message.
For everybody?
Yes.
Oh, Irene?
Yeah.
This is how my 20-year-old texts me, he's like, the gas in the house is acting funny. And I'm like, oh, okay. I'll just fire department. And I don't think that it really is. You know, like kids don't really have gas. Yeah, but I mean, it does.
Say your name. I know. Pronounce your name. You answered what I said.
Spell it out.
All right.
Yes, Jarvis.
Well,
French and
is everybody
Who's not here? BB's not.
BB.
close the door?
but I'm not. I just got it from someone.
Is that how you say that's hard? You just say like,
I just say fish starting.
that's jargon. I'm fluent in Spanish too, but I have an accent, but I think like in Spanish, boys speaking English, even though it's my second language, so
Right.
I've always wanted to think in Spanish.
So you said I'm in there? I'm in there?
You are in here. I would say De Jardín, but that's not right.
No. I'm not on the road.
You are in here, Max.
See, my time is up there.
Oh, it's 46.
Okay, so.
It's Melvin's fault.
Huh?
He was telling me all about his children and
Hold it. Melvin is innocent.
Feel free to tell Melvin to be quiet.
he was so saying that.
I stitched you up.
I know.
All right. So I hope you enjoyed reading all about wrongful convictions, eyewitness identification issues, false confessions, faulty forensic science, use of informants, jury nullification on page 26. Something the defense hopes for. Maybe you want to explain that just a little bit more from a defense.
I would never say that we hope for a jury nullification.
Yeah.
Jury should follow the rules at all times.
Isn't jury nullification one of the rules though, technically?
No, it is not.
But it's our
It is a
legal,
phenomenon.
it's our legal right to be able to do that, is it
No,
not?
it is not. It is not. It is
I thought
it is a phenomenon.
Okay.
It is
It's
not.
a reality.
Yeah, it's a
Okay.
reality. It is not part of actual jurisprudence.
Okay.
It's like, we don't have much of that because, I mean, at least I've not seen it in California. I think when you get in the deep south, there's some things that happen both ways,
Mm-hmm.
where juries do maybe something that they probably are not following the rules like they should. We want to believe that everybody follows the rules. And you would never say that you would hope for a jury to find not guilty when there's really guilty or guilty when there's not guilty. But it does happen. And there's, depending upon the example, there's history behind why it happens. Very rare though, very rare. So yes, no, it's not, you don't get, here's the definition of jury nullification, let's argue for that. You can't even do that.
Mm-hmm.
The judge would stop you and say, stop that. Cannot do that.
There's some discussion on racial and ethnic disparities on page 27. There's some good books written about that.
Yes.
It's not really an issue that we expect to see be raised in any midterm or final essays, nor would the bar or any place else want to be concerned about those kinds of issues. Socially, we should be, but in a law school, let's learn the rules. There were other terms thrown out before we get to chapter 2. Investigative grand juries, jury and bench trial. What's a bench trial? Everybody knows jury trial. What's a bench trial, Charlie?
Non-jury.
What? Did you stand up and say that?
Oh, excuse me. It's a non-jury trial where the judicial officer will hear the facts and
Determine the facts as well as the law. So Charlie, picking on you, in a jury trial, who determines the facts?
The jury,
And who determines the legal principles that apply?
the judge,
And in a bench trial, who determines the facts?
the judge,
And who determines the rules of law that apply?
the judge as well.
Okay, so the judge does the whole thing. The bench refers to this thing that's elevated in a courtroom, where the judge sits on the bench.
Yes.
Term of art for law school.
Yes.
Probation department, discretion, direct filings, right to counsel, that was all there. It's all very practical things you would need to know the minute you start practicing criminal law. But we're not there yet. So now we're moving into theories of punishment, and we begin with the Queen versus Dudley and Stevens on page 31. This is your first case to be ready for briefing. So let me remind you, when we brief the case, we'll call on a lawyer, not tonight because we're going easy on you tonight. We'll call on a law student who will start by giving us what's the issue in this case, what are the procedural facts, what are the relevant facts, what happened here, in other words. Since we have identified the issue, how does this court, Queen's Bench Court, make a decision? What was their legal analysis? What rule did they come up with? And what was the outcome or the holding for Dudley and Stevens? That's how we would brief it. I've actually written in my book, F to the margin for facts, I for issue, A for analysis, and that helps you as you read along. Just make a quick note to yourself, transfer it to your briefing paper, and be ready to brief the case. So, who in heaven's name is the Queen? Oh, stand up.
It's the Queen of England.
It is the Queen of England because this case took place in England. The year is 1884, 85. So which Queen of England do you think we're talking about? The longest serving queen, so maybe Elizabeth may have beat her by.
I thought it was Victoria.
It is Victoria, Queen Victoria. Queen's Bench, you see it's the Court of Appeals for the Queen's Bench. So that's what they call the appellate court. And you have the year, and you have bench officers by initials, CJ, JJ, BB. And this is a procedurally an indictment. Indictments come from the grand jury. So the charging document is an indictment. So did anybody capture the issue before I call on Dean Dolan? What's the issue in Queen versus Dudley and Stevens? Anybody got an idea? Yes. Yes.
Is it murder?
Is that the issue? You posed it as a question. Is it murder?
Murder in I don't know how to say it another way, but they cannibalism. I don't know quite how to say it, I'm sorry.
No, that's okay.
You got it perfectly right.
Cannibalism is correct, and the legal issue is necessity. The issue is necessity a defense to murder? Because what they did was murder the young man. And they claimed it was necessary for their personal survival. So the issue is necessity a defense to murder? And you will hear Dean Dolan tell you this more than once throughout the next year, that it all comes from this late 19th century case.
Everybody who has a criminal law class anywhere in the English-speaking world will talk about this case. My friend, my barrister that just left town from London, first case he had as well. So, is necessity a defense to murder? That's really what this case is about, right? Because you should have a little historical background. On the high seas, when sea travel was a really big deal, sometimes people would get stranded at sea. And there was a practice of figuring out a way to survive until you got rescued. And one of the practices was to fix somebody to eat, which sounds gross, but this is how they did it. And so it was never discussed in polite company back in London, but when you're out at the end of South Africa, the Cape of Good Hope, is it? And you're stranded. You're stranded, your boat got shipwrecked, and you're floating on a piece of wood, and everybody's starving. This happened. It happened not a lot, but it happened fairly regularly when boats had distress situations. So now they're back in England, and they're trying to decide, is this okay? Because remember what the criminal law is about, right? We are going to set up rules for society to follow, and if people don't follow the rules, then they're going to get in trouble. Is this okay? Because we know that there's historical practice for that, but do we give civilized sanction to this? And so the question is, if you accept, they were all going to die if they didn't eat somebody. I mean, I know that sounds just sick, but they were all going to die if they didn't eat somebody. So under those circumstances, if you accept all that to be true, is it okay to kill and eat somebody so that you don't all die? Right.
Well, I think the answer was because they couldn't know for sure the boy would have died anyways, and they couldn't know for sure they would survive if they ate him. So they couldn't know for sure that, like, it was necessity that he would save them.
That was part of
assumptions.
What happened was they got picked up.
Right, but they
didn't know that was going to happen.
They could have eaten him and still died.
And so the question is it okay to do that if you're facing imminent death? And what the court said was, and this is a really interesting case because the court said, no, you can't do that. And there's a big long story about why they said that. But this was a real, you wouldn't call it jury nullification, but there's a theory that's probably about the same. It's like, we know that this practice goes on. Do we continue to allow this practice go on? Or do we evolve in our civil society and say, you can't do that. We don't really care if you're stranded. And you can't say it was a necessity. And so there's the explanation about how you wouldn't really know it was a necessity and all that, which is what Bibi brought up. And so what you get out of this case is necessity is never a defense to murder. Okay? Necessity can be a defense to a lot of things. I mean, think about the simple example. I stole bread from the 7-Eleven because my kids were starving. So I knew it was wrong. I did it anyway. And I did it because I had no other choice. Now, you can have all kinds of factual arguments about whether they had any other choice or all that. But you see, necessity is committing a crime to avoid a greater evil. Right? A worse circumstance. So it's stealing bread. It is stealing. It is theft. I didn't steal it, but I did it because I am starving kids over here.
It's a form of affirmative defense, which we'll pick up with after the first of the year.
But this was a show trial. It was a trial to put on trial that theory that we could kill somebody if we were stranded and it would be okay because otherwise we'd all die. And what they decided was we're not going to have that to be part of our jurisprudence. Might be something you guys do out there. And by the way, how do you think they knew what they did?
They told on themselves.
Because the guys told them.
Yeah.
Why did they tell them?
Well, there was also a third man on call,
Yeah.
on board, who
The
wasn't
one
involved.
wasn't quite as
in the
all
crime.
in. That's this distinction. Who wanted to do it? Who went along with it? Who didn't want to do it?
Who didn't
Exactly.
go along with it.
And didn't go along with it.
So if we were going to brief this case, this is how it would go. Issue. The issue in this case is necessity a defense to murder. Procedural facts are really awkward in this particular case because the case is old and because the underlying premise is this really murder? I mean, it was a very original question. So your procedural facts are the jury who's heard the case. The jury is not clear if this is criminal behavior. But if it is considered criminal behavior, they would call it murder. So it goes up on appeal for the bench, the 3 judges on appeal, to help understand if this is murder, is necessity a defense to murder, to get right to the issue. So the facts are, it's 1884, and we have 4 people who are no longer on their ship. They're floating around on an open ocean, having to abandon their ship. One is Dudley, one is Stevens, one is Brooks, and one is referred to as Boyd. And they are cast away on the high seas. They have no water and have very limited food. And on day 4, they caught a turtle. And on day 12, all of that turtle is eaten. And on day 18, Dudley and Stevens suggest to Brooks that someone needs to be sacrificed. Brooks says, no way. On the 19th day, again there is talk, and again Brooks says no. And Dudley proposed a plan on the 20th day. With no vessel appearing on the 20th day, Dudley slays the boy, Arthur. Stevens helps him, Brooks does not. So there's a very elemental learning point here. Being present at a crime does not make you a criminal. You have to act and share the criminal intent. So Brooks is sitting on this, whatever they're sitting on, floating at sea for 20 days. He absolutely refuses, that's why he's not charged. Then everybody who survives this killing of Parker feed on the body for 4 more days before they're rescued. Now there are certain assumptions the Queen's Bench points out, and I casually call them what ifs. They're not facts. They're making assumptions. This is all part of the analysis before they get to the rule. And the analysis is, we're not going to assume things that are if this then that. We want facts. And that's really important to criminal law. And at page 33, there's an actual quote. This is clear, says the Queen's Bench, that the prisoners put to death a weak and unoffending boy upon the change of preserving their own lives by feeding upon his flesh, chance maybe, feeding upon his flesh and blood after he was killed, and with the certainty, the only thing that's certain here is they deprived him of any possible chance of survival. He was weak and infirm, really close to death, but you never know, he might have survived to day 24, 25, and been rescued along with the others. So the court makes out what ifs are of no use. What ifs are of no use to the court in the guilt phase. Their rule is this is murder, and the holding is they're guilty of murder, and the sentence is they're sentenced to death. Now, did they get the death sentence? No, you learned as you read through the textbook, it was commuted to less than death, and they served minimal custody. Probably because yesterday necessity was a defense to killing somebody else under these circumstances, and today it wasn't. Does that make them horrible criminals, or does that make them horrible people? I guess, for having the guts to kill somebody under those situations. So that's how you would brief a case. What do you think, Trey? Can we do it? Can we brief a case? Is it gonna work? Does it make sense?
Oh, yeah, well, I hope so, gave it to us pretty much.
Okay, yeah, no, I'm not asking you to brief it. I just wanna make sure that it's making sense. You look distracted to me, and so I thought, what's he thinking about? Okay, you got it. So you have theories of punishment next after this case: deterrence, rehabilitation. Let's isolate them, put them separate from society for a while. That's called jail. Let's educate. Let's retribution. Already talked about the difference between that and a tort. And now we're on page 37 with problem number 1. So someone tell me the facts, the assumed facts, the prosecutor's position, the defense position, and the judge, the appropriate punishment for the senior officer for murder. What evidence should the court consider in the sentence? So, let me go to that page 1237. Let's see what the call of the question is for problem 1 specifically. Problem 1, we have some facts. The call of the question is, so when you're briefing problems, the habit you want to get into is looking first at the call of the question, and there are 1, 2, 3, 4, 5 questions to be answered based on 1 paragraph of facts. So do you see where they are in that second paragraph on page 38? Whenever we're talking about a problem, we start with what's the call of the question, what's the issue? This would be the same as an issue.
And why would you think we do that? Because then you know what you're looking for when you're reading the facts. If it's asking you, is this a murder, then you would be looking for, is there something that shows the murder? Is this a dog leash violation? Then you would look to see, are there any facts regarding a dog leash violation? So the call of the question will end up being the basis for your conclusion in every area. But you always look first. What am I supposed to be looking for here? Now, this is a little complex, because usually the call of the question is 1 question, not 5 or 6 or whatever we have here.
Everybody got the questions in mind? Is it appropriate to charge the senior officer with murder for the death of the 6 men thrown overboard? Should other crew members who participating in doing the actual throwing also be charged with murder? If the senior officer was charged and convicted of first-degree murder, what is punishment by life in prison without parole, or what punishments should the prosecutor seek, or the death penalty? What arguments should defense counsel make to mitigate the punishment? What evidence should the court consider in deciding the appropriate punishment? So next week with problems, I would call on one of you, and you would identify the issues, which there are 5 at the end. You would recite the facts and take a stab at the issues. With the problems, as compared to the cases. With the problems, we're opening up the opportunity for you who are briefing a problem to act like a prosecutor and act like a defense attorney. Prosecutor's gonna argue X, the defense attorney's gonna put an emphasis on Y. X, Y, Z, not WHY. And that's what we focus on in problems.
Well, I was just gonna say also, because when we do problems, there's all kinds of people sitting here, and sometimes you remember what's in that question and what's not. What we would have you do is stand up and read, first of all, the call of the questions off. I'm gonna do problem number 1. So I'm gonna say, okay, the call of the question is it appropriate to charge a senior officer with the murder for the death of the 6 men thrown overboard? And I'm gonna read all that. I'm gonna say, okay, this is what we're looking at. Then I'm gonna actually read the problem. I'm gonna say, a small passenger boat was sailing in the North Atlantic, struck by an iceberg and sank. The passengers and the crew. And I'm having you read that because I want you to make sure that everybody is on the same page as you are as far as talking about this. So when you read it up until the end, it may have been necessary to remove and save the lifeboat. Okay, now, then you go to the call of the question again. So, is it appropriate to charge a senior officer with the murder or the death of 6 men thrown overboard? I'm the prosecutor and I say, yes, it is. I'm the defense lawyer and I say, no, it isn't. And sometimes there'll be 2 of you that'll do this for us.
And you're gonna say yes because and no because.
Exactly. And
That's no good to say yes, no.
yeah, well, and see, this is the problem when you start making the conclusion the goal of an essay, right? The conclusion is after you've done everything else, right? I don't want to hear, here's the issue, murder. Yes, it's murder. How'd you get there? Get it? So it takes a while. But when we do problems, mostly we'll have you read the problem, not into the record, but before the class. And then you might say, I'm going to take the position of the prosecutor, and you might say, I'll take the position of the defense lawyer. And then you'll say, this should be murder, and here's why. And she'll say, well, it shouldn't be murder, and here's why. So that's how we sort of mess around with the science of the problem. Okay? So just it's learning the process. It's a pretty simple process. Just remember, always begin at the end. What are you looking for as far as questions that you have to answer? And then you go back and read the whole thing, and you can stand up and read it. And it takes a while. Read in front of everybody else sometimes flip you up a little bit, but it's okay. You know, but we want you to go ahead on.
As a question on the process, will you ever just assign us to the prosecution or the defense? Because my question is, as a prosecutor, sometimes there's probably cases that come that you have to, that you might see better from the other side, and how don't we need to learn how to do that?
The answer to that is not exactly.
Okay.
So you might say, I'm going to be the prosecution, and we listen to what you have to say, and then we say, okay, now you're the defense. What would you say?
Okay, so we will.
Get it? You got to get both sides.
Okay.
So yeah, sort of. Rather than assigning you, we might assign you because we'll say, okay, you give a good argument for the prosecution. What's the argument for the defense?
Okay.
Well, okay, now you got to work on that, right?
Practically speaking, because I'm keeping track of your participation, practically speaking is we'll get to problem 1 and I'll say, who wants to brief problem 1? Now you have pre-prepared. You found problem 1 really strikingly wonderful, and you want to be the prosecutor. I'm going to see you volunteer, and you're going to stand up and say, I'm going to be the prosecutor in this. Now, Edola's correct. You may get to the end of this wonderful argument. As a lawyer, you're learning all sides, and there's definitely more than 2 in most situations. But if you can't see the defense side, you're not an effective prosecutor, and vice versa. And so we'll be doing that training along the way. And, you know, we had a police officer in the 1L class last year, and we had a gal who's been working for the public defender, not public defender, but defense contract person. They couldn't have been more prosecution oriented and more defense oriented. And so the fun for me, because, you know, we need to have fun too, is I would encourage her, you're going to be the prosecutor, and him, you're going to be the defense. And then I would figure out how long it would take before they were naturally beginning to see both sides.
I'll never forget our very first criminal law class in the first year that we had the law school in 2012. This really smart guy who happened to be a doctor was coming along to learn to be a lawyer.
He testifies in court as an expert, so he really just wanted to learn to be a lawyer.
He stood up and gave us the prosecution thing. And then I said, okay, now give us the defense side. And he stopped for a minute, and then he got the light bulb, you could tell, went on right away. And he went completely to the other side. It might take you months to do that, but I'm telling you, you can't be a good prosecutor if you don't know what the defense is doing. You can't be a good defense lawyer if you don't know what the prosecution is doing. You gotta see both sides. If you can't see both sides, you're not doing the job. Because every case for sure that we have in the book, because they're intended to do that for you, to make you see both sides, or to at least force you to figure out what the arguments are. The best practice is when you can't figure out what a defense is, or you can't figure out why the prosecution should get the conviction, and you have to really manipulate what you see and how you see it so that you can make the argument. Because you should be able to argue both sides. So we want you to do that with everything. There are no absolute answers in anything in the law. It's all about the facts and how the facts are related to the element of the crime.
So when you're writing your midterm and final exam, they are constructed for you to see those sides. And so if you get through this process here and you're done with 15 minutes to spare and it's so clear in your head that this is clearly a prosecution case, you have missed something. So you need to learn to look at both sides.
Yeah, when we give you an essay, we'll give you like 3 or 4 paragraphs. And it's designed so that every element has some both. Yes, it's there. No, it's not there. And you're supposed to see that. You're supposed to say, here's the reason why, and here's the reason why not. That's the whole idea. That's what legal thinking is about. It's not about getting the right answer. It's about learning the thinking process. So what if you're on the wrong side? What if they've got all the good evidence and you're stuck on the wrong side? Believe me, I know what that's like. And I'm telling you, you have to figure out something. And the exercise of doing that eventually gets you to the point where you can do it just like anything else you've learned and really mastered. And that's what we're spending the whole year on. And you'll all be real good at it. And if you're not, we'll point out to you that you're not and we'll help you. Okay?
So were you going to continue with we're going to prosecute the senior officer with the briefing?
What I would like to have somebody do is read it.
Okay.
So if anybody wants to volunteer to read it.
Read the problem?
Yeah.
Anybody?
When we do problems, a lot of times it's good to just read the whole thing out.
Who wants to read the problem? I'm looking at you, Miguel. Don't want to leave you out. Why don't you read the problem, beginning of
There you go, Miguel.
37.
Okay, perfect. The problem 1, right?
Right.
Okay. A small passenger boat sailing in the...
Stop.
Yes.
Go to the end and read the question first.
Oh, I see.
Okay? So don't just take off. I'm just giving you a hard time because that's what you have to do. So you'll never figure it out.
Okay, perfect. It is appropriate to charge the senior officer with murder for the death of the 6 men thrown overboard. Should other crew members who participated in throwing the men overboard also be charged with murder? If the senior officer was charged and convicted of first-degree murder, which is punishable by life in prison without parole or death, what punishment should the prosecutor seek? What arguments should defense counsel make to mitigate the punishment? What evidence should the court consider in deciding the appropriate punishment?
Now go back to the top.
Okay. A small passenger boat sailing in the North Atlantic struck an iceberg and sank. The passengers and crew escaped in 2 lifeboats, which became separated. In one boat was 9 members of the crew and 32 passengers. The lifeboat began to sink slowly when a leak developed. Although the crew and passengers were able to bail out much of the water, the leak worsened and the waves threw so much water into the boat that it was on the verge of being swamped. The senior officer on the lifeboat ordered the crew members to throw male passengers out of the boat in order to save it. Over the next hour, 6 men were thrown overboard, some of whom resisted violently, and none were found alive. No member of the crew was ejected from the lifeboat, nor any women or children. The senior officer ordered that if a man's wife were on the lifeboat, he should not be thrown overboard. After being rescued the next morning, all agreed that they would have drowned during the night if a number of people had not been thrown overboard. Although it is not clear exactly how many and it would have been necessary to remove to save the lifeboat.
Okay, so now you just gave it the whole factual scenario. Now go back to the first question.
Okay. First question, is it appropriate to charge the senior officer with murder for the death of the 6 men thrown overboard?
You're the prosecutor. Why should he be charged with murder? Because he was responsible for throwing 6 men overboard.
I think since he was in charge, he did not have the authority to just start throwing people out of the boat.
Well, let's go back to the previous case. What did we learn from the Queen versus Dudley and Stephen?
That necessity is not a defense for murdering someone.
So, if your question is it appropriate to charge a senior officer with murder for the death of the 6 men thrown overboard? We at least know necessity is not a defense. That's at least,
right?
So then you might ask yourself, well, is he responsible for their death? Think so?
You're the prosecutor.
I don't think he's responsible for their murder.
Well, you're the prosecutor, though.
You're the prosecutor. You're prosecuting the case.
We'll let you be defense, but if you're the prosecutor, what would you argue? The answer is yes, he is responsible for their murder because. What would be the argument?
Yes, he is responsible for the murder because he instructed people to throw them overboard.
That's almost right.
To search the death.
How about he was in charge and he instructed the men to throw the people overboard?
That's
okay.
The argument.
That's the prosecutor's argument, right?
And what's the defense argument? You're so quick to go there.
The defense argument would be no. Because he did not directly murder them.
He didn't touch them, he didn't pick them up, he didn't fight with them as they resisted, he didn't toss them overboard. That's the defense argument.
That would be one. Would be another one. Everybody would have if he didn't have him throw those guys overboard. Right?
Right.
He saved all those people by throwing just 6 people overboard. Fantastic for the people that lived, right? But then we're back to the problem of
prosecutor's response is necessity is not a defense to murder.
Can you see how we just went back and forth on that?
Yes.
So what's the next question, Miguel?
Next question. Should other crew members who participated in throwing the men overboard also be charged with murder?
What's the prosecutor's argument? Yes, because?
Yes, because they physically threw the men overboard
To their death, with the
to their
intent.
death.
And what's the defense
Well,
argument?
don't leave that before. And what else? And they can't say I was just doing what the captain told me to do, right? They personally threw the guys overboard. And they can't blame it on the captain who was just telling them to do it. Like the Nuremberg trials, remember, in Nazi Germany? I was just doing what I was ordered to do. That wasn't a defense, was it?
No.
Just telling you, if you're the prosecutor, you want to cut that off, right? Don't tell me the guy told you, so you're not responsible. You're responsible. You threw them out. You know they're going to die.
So what's the defense argument?
Defense.
Think about the opposite of that.
Well, they were just following orders from the person in charge.
That's at least some place to go, isn't it?
Because for murder, you have to prove the mental intent, and they're gonna claim they didn't have the mental intent. Their mental intent was to follow orders, not kill somebody else. It's weak, we're not saying it's strong.
Well, and you can, I mean, depends on the facts in any particular case. I did it because the captain told me if I didn't do it, he was going to shoot me in the head. Does that change? It's still a little iffy. Can you kill somebody because somebody is intending to harm you? Interesting, but at least gives you a little bit more to talk about.
Couldn't he say they're under duress? I mean, that's kind of the same thing.
Yeah,
as what you were
although I will
saying.
tell you, this little advance for you here. Duress is also not a defense to murder. Necessity and duress are related.
Okay.
They're not the same.
They're not the same at all. But yes, then you could say that, and
But it wouldn't work.
come back and say that word. Well, that, maybe, but you don't know. You have to dress it up a little bit different.
Good question.
Okay. So can you see this going back and forth?
I see it going back and forth, but wouldn't we have to know what the elements of murder were according to this day? Because like we're making all of these facts without not knowing like they met these elements
Right.
to be murder.
The unlawful killing of a human being.
But I mean,
But
That's the element.
that's the element of, I mean, unlawful.
With malice aforethought.
But
that's okay. You don't have to know the elements right now. We're just.
I'm just asking, you're asking me.
We're just having a general discussion now. What are your arguments if you say it was murder, and what are your arguments if you say it was not murder? We'll get back to the elements of murder and all that and the subtleties involved.
So Renee, let's take the onus off of Miguel. You start with, if the senior officer was charged and convicted of first-degree murder, which is punishable by life in prison without parole or death, what punishment should the prosecutor seek? Life or death? And why?
You want me to reread it?
Nope.
I want you to make up an answer.
Be
You're
a
the
prosecutor,
prosecutor.
be a defense attorney.
Okay, let's see.
So here's what you do. Death, because that's the prosecutor's position. Life without possibility, because it's the defense position. So what are your arguments for death?
Because he made the decision and he didn't know if the boat was actually going to sink.
And there was 6 people
Six
killed,
people. Yes.
multiple murders.
That's the best argument you have. 6 people are killed, not just 1. 6. That's
And it
bad.
was somewhat indiscriminate, because the factual point you don't want to ignore here is, there's no evidence to say he needed to kill 6, so keep that floating.
And none of his employees were let him off.
Right.
Even though we said, throw him off.
And what would you say if you had to make the argument that it should be life and not death?
You want to mitigate?
He thought that basically the boat wouldn't sink, it wouldn't completely sink if he throw people off.
What other little fact is buried in there? Stand up and help.
A mitigating factor for the defense would be that the captain said that any man whose wife was also on board would not be thrown over. So some men were not thrown over.
And it's because he recognized that it was a husband and wife and was not intent on killing just anybody, right? And you see, that's a nice little nugget there, isn't it? And what else? What else have we not mentioned that would be a reason why you don't give him death? How many people didn't die?
The last, I don't know.
Was that
32, so.
Yeah, so he saved a whole bunch of people, and while it's awful that he had the guys thrown over and there were 6 people who died, it could have been nobody survived.
Right.
Right, so that's a reason for, yes, it's a bad thing, but let's face it, life without possibility is not much better than death. If those are the only 2 possibilities, so you're looking for something that helps you to argue for death if you're the prosecutor, and something that helps you to argue for life if you're not. So it's all buried in the facts somewhere, right? That's our job. Find the facts and then explain why the facts lead you to a conclusion. And you're right, we don't have the elements of homicide yet, or killing, murder, but don't worry about that for right now. You're digging for facts in here. And you found the good facts about not throwing over a guy whose wife is on the boat. That's a pretty interesting thing. It's more subtle to say, look at all the people that weren't killed, but it's still there. I mean, they say 6 out of 32 or whatever it was. So that's a pretty good reason why you should give a guy a break. Suppose. Imagine being stuck out in the Atlantic.
Okay, considering the time, I'm gonna move us to problem number 2. And Bibi, why don't you handle problem number 2?
Okay, so starting with the call, which of these 2 individuals would you prosecute? How would punishment theories come into play in making your decision? Does the availability of a civil enforcement proceeding to recover unpaid taxes affect your decision about which defendant to charge? In the problem, prosecutors often have limited funding and cannot prosecute all of the crimes that occur in their jurisdiction. They have discretion to pick and choose the crimes that they wish to pursue, although they cannot use their discretion in a way that uses impermissible criteria such as race. Assume that a federal prosecutor has 2 possible defendants that because of limited funding can only proceed against one of these 2. Potential defendant A is a wealthy hotel owner who failed to pay a significant amount of money in taxes, but the amount is less than 2% of the total amount that is due that year. There's likely to be significant coverage of the case in the local media. Potential defendant B waits tables at a restaurant and fails to report a large amount of the tips he received on the tax return. The amount of money due to the government is small, but it constitutes over 1/3 of the person's income that year. Okay, so the first question, which of these 2 individuals would you prosecute? And I said the wealthy person, because it would serve as a greater deterrent because of the publicity of the case, so people would see it and it would be like, I shouldn't do that. And also, I think it sends a message that rich people aren't above the law because, I mean, unfortunately they often are right now, and they behave as if they are, and they just get away with so much more than poor people. So I think prosecuting them would be the better choice.
But only 2% of the taxes versus 33 1/3%. How do you justify that?
Because the 2% is more money to the government, right? So the government would be receiving back more of the money it's owed, right? Next question? Okay, good. How would punishment theories come into play in making your decision? Oh, that's where I put, it would serve as a greater deterrent, because that's one of the theories of punishment, right?
What about rehabilitation?
I mean, I think either of them could be rehabilitated, right? I don't see either of them being more likely to be rehabilitated.
If you had to choose one, which would you choose?
Choose which person?
Yeah.
Which person?
To be rehabilitated?
Oh. Yeah, I think rich people need more rehabilitated. Because I mean, the harm isn't like, they're just trying to survive. I guess I feel for them more, which maybe isn't how I should be weighing this decision based on my emotions.
But what if you didn't feel more for them and you had to argue that the poor person should be receiving rehabilitation? How would you say that? How would you deal
Well, because it was a greater percentage of their income that they didn't pay.
And maybe everybody that works in the restaurant would know you better be careful.
Right, or people in,
So the same argument you have about sending a message.
Right.
Could be there.
Mhm.
How about the rich person being rehabilitated?
yeah, I mean, they could, I mean, I'm biased, because I just think rich people are more likely to try and get away with things. Because they know, I mean, maybe because they usually know they can pay their way out of things. So, I mean, maybe, yeah, going to jail for a little bit would make them less likely to do it next time, which I suppose is almost rehabilitative. Or it's not,
Going to jail?
it would be,
Rehabilitative? Some might think that.
It's more punishment.
yeah, that would be, I guess deterrence for them. Or I guess education as well. Right?
So try the third question.
Does the availability of a civil enforcement proceeding to recover unpaid taxes affect your decision about which defendant to charge? No, because criminal and civil cases should be treated like they're separate, right? They're not.
Well, but what if you had a civil enforcement provision of the criminal law that said you can fine a person 3 times the amount of taxes that they didn't report and pay? That'd be good for the wealthy guy, right? Because you get a lot of money for the state, right?
Right.
But it really wouldn't help you too much for somebody who's living on tips, would it?
Exactly, yeah, so
it might be,
then you should go with the wealthy guy.
well,
Wait, no, wait, I'm sorry.
do you do civil enforcement instead of filing a criminal charge?
Would you do it instead? Why can't you do both?
You can.
Okay,
On the other hand, there's limited resources.
okay.
We want money, right?
Yeah, because I suppose the money trial could be just as publicized, right?
Yeah.
As the criminal one.
So I just want you to see you can make an argument for both in every question. And that's what you have to do. If you think it's only one answer, you're missing it. But I mean, this is a good example of there's all kinds of stuff. Let me ask another question. There's good stuff in there, right?
So let's move on to people, state versus Jensen. This is in Idaho, where Idaho calls their cases state versus. So look at page 39, and Drake on that page, tell me where you find the issue.
On which page?
39, first page of the decision. Where on that page? See, I have marked all the way down the first page. I've got facts, procedural facts, issue, and a couple of rules. Where do you see the issue?
The issue is whether the sentence was excessive.
And where do you see that on the page?
At the bottom of the fourth paragraph.
So you've identified the issue, and it's really just hidden there in the procedural facts. Jensen appeals claiming that her sentence was excessive, and you flip that over into a question, and the rest of the case makes sense. Was her sentence excessive is your issue. Now, you don't have a court saying the issue in this case is whether or not the sentence was excessive. It's right there in the procedural facts, but you had to flip it over in your head. Thank you so much. Where are the procedural facts? How about David? On that page, just stay on that page. There's 2 procedural facts areas on that page. The facts that tell you procedurally how Ms. Jensen got here to the Court of Appeals, procedurally.
The first fact is Jensen pled guilty, and well, hold on, let me.
No, you're correct, that's the paragraph.
Okay.
That's one of the 2 paragraphs.
Okay.
Procedurally, she's there because she pled guilty. There's no jury trial. And she pled guilty to what? First degree murder.
First degree murder is.
And it was a plea bargain because you find out that the state dismissed something.
Yes, they dismissed the conspiracy charge.
And they
took the death penalty off the table.
yes. And then there was a hearing, sentencing hearing, we presume, they don't say so, but the sentencing hearing.
An appellate review of the sentence.
And now we're at the appellate review. She was sentenced to determinate life term in prison. She's calling that excessive. And we know at the top, she's appealing from her judgment of conviction and fixed life sentence imposed upon her plea of guilty to first degree murder. So you know from identifying that in this case, that this is all about when does a sentence become excessive. But we have to put it in context. So on this page, where are the facts? Not the procedural facts, the crime facts.
What she did, she injected, using her skills as a nurse, she injected, the girlfriend of her ex, and watched her die. And there were issues of torture and excessive suffering on the part of the victim. And as I recall this case, she had threatened to do this before, so that came into play.
Okay, no, stay right there. That was excellent in two ways. One, he's right, those are the facts. But he focused immediately on the facts that were relevant to whether or not the sentence was excessive. Most 1Ls on the first night would say, well, in July 1999, Jensen's husband left her and moved into an apartment with a victim in this case, and they have a 3-year-old daughter, and she wasn't too happy about that. But she went right to the gravamen of how this woman was killed, and for what reason, and this wasn't the first time. So.
We're assuming that was intentional.
I just, on the spur of the moment, yes, sir, that was just what I thought.
Yes, and facts specific to intention to make it appear as though the victim died of a drug overdose. So you know she's intending to overdose her on insulin and kill her.
And watching her suffer.
Watched her suffer.
All that
So-
goes to what sentence you can get.
Yes, sir.
Okay, so you can sit down, we've done issue, procedural facts. Where are the rules? There's 2 rules identified on page 39. We haven't even turned the page yet, we've got 2 rules. Charlie, do you see the rules at the bottom of page 39?
Yes. It said where a sentence is not illegal, the appellant has the burden to show that it's unreasonable.
That's one of the rules, and you're right, I misled you. There's actually 3 rules. A sentence just above that tells you what the appellate's review of a sentence will be, and that's a rule that we know from what appellate courts have the authority to do. They have the authority to determine whether the trial judge who imposed the sentence views the discretion standard. And then the next rule, which you pointed out, is where a sentence is not illegal, the burden shifts to the appellant. And then there's a rule still in that paragraph after the the asterisk further down.
A sentence may represent abuse of discretion if it is shown to be unreasonable from the facts of the case.
That's part of the rule, and then a sentence of confinement is reasonable if it appears.
At the time of sentencing, that confinement is necessary, quote, to accomplish the primary objective of protecting society and to achieve any or all of the related goals of deterrence, rehabilitation, or retribution applicable to a given case, unquote.
And then we go down to the very bottom when the appellant, who is Ms. Jensen, contends that the sentencing court imposed an excessively harsh sentence, we, the appellate court, will conduct an independent review of the record.
having regard for the nature of the offense, the character of the offender, and the protection of the public interest.
So the author of this Court of Appeals decision has given you in one paragraph all the rules related to what they're gonna look at, how they're gonna look at it, and what they're looking for. Okay?
Sorry.
So,
Was that last sentence a rule, or what was it?
yep, it's a rule as well. There's more than 2 rules in that sentence. Each sentence is almost a rule on appeal. How they're gonna handle it. So then the rest of the case, where you have nature of the offense, character of the offender, protection of public interest, before you get to the holding, is what I call analysis. We know what the question is. Was the sentence excessive? We know the confines of the Court of Appeals review, and they're gonna look at the record. They're not gonna hear testimony, they're gonna look at the record. And when they look at the record, they tell us all about what they consider to be the nature of the offense. They tell us all about their opinions concerning the character of Ms. Jensen and where they get that information from. They kind of review what the trial court heard. Actually, the trial court did hear it in the sentencing hearing. You see the testimony of her husband, and then they look at, and we want to protect public interest. And you see another rule at the bottom of page 42. Indeed, the primary consideration in sentencing is, and presumptively always will be, the good order and protection of society. And they take that rule and they talk about the facts and they analyze it. And what's the holding, Charlie? You see the holding at the end of the case?
Yes.
Last paragraph, 43.
Having thoroughly reviewed the record on appeal, we conclude that Jensen's offense was so egregious that it demanded an exceptionally severe measure of retribution and deterrence, regardless of Jensen's potential for rehabilitation. Accordingly, we hold that the district court did not abuse its discretion in imposing a determinate life sentence in this case.
So that's kind of what we do when we brief a case. There are a number of asterisks throughout this case. When you read a case that has been taken from a real case, but they've edited it down to make a point in the case book, they'll show you where they've done some major editing. And they do that by inserting those 3 asterisks. And we left some stuff out.
What do you think they took out?
The analysis?
Stuff that wasn't related to nature of the offense, character of the offender, protection of public interest, right? Since that's what we're studying in this case, that's what they're gonna give you all the information on. And other stuff that might have been in the case, they're gonna leave it out. If you go look at any of these cases up in a law library or online on LexisNexis, you'll see that they're much longer than the cases in the book, because everything that was possibly brought up. This case was specifically about using discretion in sentencing.
So one curious fact, if this occurred in California and the cause of death was as it's described, she's also eligible for probation. Nothing about his crime facts that make her ineligible for probation. That she used a gun or a knife, she might have been ineligible for probation. But she's also eligible for probation. Nobody's even thinking about that, and maybe that's not true, I don't know. But just to point that out to you. Yes.
I have a question. Is there a way to summarize all of the rules in one sentence or so?
No, not in this case.
Okay.
Because the rules all relate to the authority of the appellate court, what they look like in this sort of situation.
Okay.
If this were a burglary case and we were trying to figure out what constitutes a breaking, you would get to a far more precise rule.
Okay, but so in a brief, it would sort of just be all of the stuff that you said. Okay. Thanks.
That's what you have a lot of rules, but if you wanna summarize it, when a sentence is not illegal, the appellate court has a burden the appellant has a burden to show that it does was unreasonable and thus a clear abuse of discretion.
Okay,
That's
so
what this
first-
case is about.
Okay.
And then we say, well, how do we do that? How do we find out about that? What do we consider in order to decide that? So there's separate rules.
Okay,
That's
good,
what you're trying to do.
okay.
You're looking at a sentence and you're saying, this is what you have to simplify. You're saying, well, is that okay or is that just unfair and too much?
Okay.
That's really what this case is about. How do we determine that? Well, there's some other rules. Well, we can look at the character of the person, the nature of the offense, and the public safety issue.
So then
But that's a
we,
good question.
so then we have some notes and comments. This textbook does notes and questions periodically. Some of it is just to highlight certain things that you just learned in the case and teach it to you in a more summary fashion. There's nothing necessarily that we're gonna talk about. When you study, you make sure you read through it, but your time in class is gonna be spent going through those cases and briefing them and problem solving primarily. So I'm moving through here. You saw what happened with the punishment of Dudley and Stevens. What the role of the prosecutor is, what the role of the defense attorney is in sentencing. And then on page 44, there is a note. Let me see if I can find it specifically. The court can consider additional facts. This is the sentencing court, not the Court of Appeals, including crimes that were not charged, crimes that were not proven beyond a reasonable doubt. They can consider a number of different avenues at sentencing beyond the verdict. Yes.
So what you're saying is, once you get through the trial, you can admit inadmissible evidence to impact the
It's
system.
not inadmissible evidence.
Well, I guess it's not.
So here, let me help you with this.
Okay.
There are no rules of evidence in sentencing.
Okay.
You're evaluating the person, the crime, and there's very lax rules on what comes in. Because now remember, this is about sentencing. It's not about guilt or innocence. When you're in guilt or innocence, yes, you don't want to have inadmissible things that would sway people and make them find guilty when they shouldn't be, because they're looking at the other offenses. When you get to sentencing, almost anything.
We're trying to get the whole picture of the defendant at sentencing. Yes, sir.
Follow. So as a prosecutor, if you have a case like, let's take a R. Kelly or a Bill Cosby case where you have a ton of different defendants, you would go with your strongest defendants to get the conviction and then utilize all the other
Probably.
information to do that? Okay, just.
Probably. And with the court's permission at sentencing, the other victims can come in and tell the court what happened to them. You know, even though we expect the court to be smart enough to realize that Cosby hasn't been convicted of those other crimes.
Right.
And keep that separate but informative. We expect a lot of the bench officers and the lawyers and the jurors. We're approaching problem 3, and then we're going to go into our definition of assault and review and do a couple hypotheticals related to our larceny. So problem 3. Magna, why don't you just turn the page over? Yes, go to the questions and then go back and read problem 4.
What steps should a defense attorney take prior to a sentencing hearing to maximize the chances of more lenient sentence for Michi? What witnesses, if any, should the government call at the sentencing hearing? How is the information relevant to the appropriate sentence for the crime? How is the information relevant to the appropriate sentence for the crime? And if asked, what sentence should the prosecutor and defense counsel recommend to the court? And the problem is, Michi was arrested after swinging a beer bottle at the patron in a bar with whom Michi was having an argument. Michi is a graduate of Central University and got into an argument with the victim about the merits of the various local colleges. The victim, a graduate of State University, shouted, I hear you don't even need a room temperature SAT to get into Central. And Michi responded by swinging the bottle at the victim, who ducked out of the way. Michi's actions were observed by two off-duty police officers who promptly took Michi to jail. After retaining a lawyer, Michi agrees to plead guilty to simple assault, which carries a punishment of a sentence of up to 1 year in a county jail. Michi will be meeting shortly with the probation officer who will prepare a pre-sentence report for the judge who will decide the sentence. How will the prosecution and defense attorney use the following information in the preparation of the report in an argument to the court prior to sentencing? Keep going.
Please, the rest of the facts.
Michi was convicted for being a minor in possession of alcohol while in college, which Michi explains was after a particularly rowdy party. The victim, Kale, was convicted a year earlier for resisting arrest for forcibly punishing aside a police officer who was trying to remove Kale from a sports bar at which Kale had an argument with the patron about a local college basketball teams. Michi has been employed as a bank loan officer for 3 years and will complete an MBA in 3 semesters. Michi recently broke up from a long-time relationship with Dale, and Dale has sued Michi for removing a plasma television from Dale's apartment that Dale claimed was a gift from Michi.
So now it's time for sentencing.
So what steps should the sentence, should the defense attorney take prior? Well, the steps for a defense attorney should be finding the character of Michi, interviewing people, looking at his record, stuff like that.
And based on what we know,
Based on what
if you're
you
the
know.
defense attorney, what facts will you underline for the court, emphasize for the court that would mitigate the sentence, reduce it to something less than a year?
That he.
It's a she. Michi's a she.
That she threw. Didn't he actually hit the?
Nobody's injured.
Nobody's injured.
What else?
So that and
So sentencing is all about rehabilitation, punishment, deterrence, retribution.
You would emphasize that she's a good student. Maybe you should suggest that she's going through distress or something like that.
Why don't you go down the list?
Down the list.
There's 1, 2, 3, 4 bullet points.
Mm-hmm.
Okay, so tell me what you would do with those.
It's a good employee.
No, start with the top of the list.
She's the defense attorney.
She's a minor. She's a minor, and the bar should not have provided alcohol.
Okay, so this is sentencing with number 1. If I were the defense attorney, I wouldn't even bring it up.
Well,
It's her prior.
only if the prosecution brought that, and it's a
Right.
very
And if it's in the probation
minor, and
report,
when choose it to.
and it's in the probation report.
Right.
So the defense attorney can't ignore it, is what you're saying.
Right, if it's not in there, of course you don't bring it up.
Yes.
But if it is in there, you say, this is really a minor, juvenile matter, it was a misdemeanor, really shouldn't carry anything.
So you can talk in those terms.
Mm-hmm.
Are you gonna bring up the fact at sentencing that the victim appears to have a propensity for drinking and getting in fights? Which is number 2.
If you're a defense, yes.
Okay, what about number 3?
He started it.
Right.
Okay, What about number 3?
Number 3, Michi was an employee. It's an employee and shows that it's a good contribution to society.
She's well on the path to rehabilitation. She has lots of positive opportunities.
Aberrant behavior.
This, yeah,
She's a hardworking person who's doing a great job getting an MBA, and this is out of turn, right?
And then really, she recently broke up. She can say that it was a gift and it was within her property.
Or how about it's irrelevant? Doesn't have anything to do with this. Totally separate subject. If it's even in the report, if it's not in the report, you wouldn't bring it up, obviously. But if it's in the report, and there's a civil, isn't there a civil case pending here? Sued Michi. You'll say that's a civil case, and honestly, there's 2 sides to every story. It doesn't show any criminal conduct, and it shouldn't be considered. Right? That if you're the defense.
And so the one other question for the defense is, therefore, Your Honor, I would recommend that the court sentence my client how?
As juvenile.
Well, she's not a juvenile now, is she? Is she a juvenile now? I don't know.
I can't remember if I read.
She's in a bar. She's a graduate.
Working in a bank.
Yeah, she's a graduate of the university. She's only 21. So you're going to have to recommend something within 364 days.
It's a misdemeanor.
It is a misdemeanor, so the maximum penalty is
under a year.
1 year minus a day. You're the defense attorney. What do you want the court to do?
To sentence to less than a year.
You have no idea what
I'm
the
not
options
sure.
are. But you might argue that she served weekend custody so she can keep her job and stay on the road to rehabilitation. No custody at all, of course, with the
Home detention device.
home detention device.
Or how about 3 years or 2 years of summer probation and 2 AA meetings a week? Bring me back proof of that.
That sounds good.
Get a handle on that drinking. So we're gonna let you sit down. Melvin's gonna stand up and be the prosecutor and answer the question, what witnesses, if any, should the government call at the sentencing hearing? If you're gonna represent the prosecution, are you going to call that victim, Kale, as a witness to encourage the court to sentence Michi more seriously than?
I would call Kel.
You would call Kale because?
I think that calling Kel and also the bartender could maybe help establish that the drinking really isn't under control, because people typically go to the same establishment to drink. And so if there's a relationship there, it would show that this might be a more frequent issue than you would thought. Also, if you're having a contentious breakup, you can also shed light probably on.
So you might call Dale?
Kale.
Kale's the victim.
Oh.
Kale's the victim, Dale's the
I would call
ex-boyfriend.
Dale also, maybe because that would also show that she might have contentious issues before. You have where he first was, she was rowdy when she got arrested with the drinking, and then now she's in a fight at the bar with Kale, and she swung at him, and then she shows us a symptomatic pattern of being petty almost, in my opinion, I guess. And so I would use Dale to say, and when we broke up, she took the TV back that she gave me the gift because she had a provocative.
So focusing on Kale, the victim, for a moment as a
Okay.
prosecutor,
All right.
you would call her, but if you call her to the stand, you make your case vulnerable in a couple of ways.
Okay.
Now that Kale's on the stand, the first question the defense is going to ask Kale when you're all done with Kale is, were you hurt? And Kale will say no. She didn't hit me with it.
But I can't sleep anymore because when she swung that bottle at me, barely missed, and I'm telling you right now, I had to go to a psychiatrist to get some help because of that bottle that was being swung at me.
Or embarrassment.
Well, that's a victim impact statement. I've got to get something out of it.
Okay.
And you also need to be careful because how Kale's going to be able to point out how silly this fight was. They're arguing over which college is better and how quickly your Michi was provoked to swing a beer bottle over the issues. And that's important to the prosecution. This is a pretty kinky misdemeanor, Mickey Mouse thing to be arguing about, and how quickly Michi is provoked. So that's really what you want Kale for.
Okay.
So, question, comment? David?
Yes, ma'am. And to me, I don't know if I want to call Kale as the prosecutor just because he was convicted for pushing a police officer. So the defense is going to argue, Mr. Dolan can argue, well, Kale provoked this. And given the history of Kale being convicted, that could bring some doubt as to who started this whole thing. And the other thing I want to ask about or point out is, if I'm the prosecution, I want to call the police officers, right? Because they arrested me, see?
This is after the conviction for sentencing.
Right.
You called the police
Okay,
officer.
so that's what I've already
You
called.
called Kale already too.
Okay, so,
Unless you reach the plea negotiation.
Yeah.
so the police have already been called, and so they're in the sentencing phase? Is that what you're
Sentencing.
saying? Okay, thank you.
So we're gonna stop there in the book and start there in the book next week. But we're gonna switch. According to your syllabus, you were gonna come up with a definition of the crime of assault. And so who has one and what was your source? Did you go to the dictionary? What did you do to get your definition? Who wants to start with that? Sooner we start, the sooner we're out of here. Everybody found it?
Somebody raise your hand and spit out a definition of assault.
I have a definition.
Okay.
All right. So it's a physical attack on another person.
That's not bad. Where did you get it?
I used
What's your source?
dictionary.
You went to the dictionary and looked up assault.
No, sorry, virtual dictionary.
What is a virtual dictionary?
Word document has the option of a smart lookup.
Okay, dictionary on the computer. Got it. Okay. Who has a different definition? Or the same definition? Yes? Renee?
The way that I remember it is basically assault is something that you see coming, a physical harm done to you.
You see coming a physical harm
Like
to you.
or not just physical harm, not physical harm, but like a wrong done to you. Yes.
Okay. But you're remembering that from the work you do in the law offices?
I think so. It's just something that came. Assault is something you see coming.
Okay.
I guess.
All right. Drake, do you have something?
From the courts learning yesterday, because what catches in my mind is the ability to see it. Is that's a necessary part of it. If you don't see it coming, you can't constitute an assault. Is I think what we discussed, but I don't know if it might be different.
Okay, that's a good distinction.
Yeah, implying non-consensual touching, that seems like a necessary quality. So, yeah, that's what I'd go with. So,
and we have to distinguish criminal assault from tort assault,
yeah,
but we
so
will.
exactly.
Yeah. Charlie, did you get something?
Yes. The
What was your source?
yesterday as well.
Okay.
The intentional and immediate apprehension of another.
Okay. All right. You got the right language.
You're getting some words in there, pretty good.
Yeah.
And as a resource to you, those jury instructions, since you're sitting right at your desk going over jury instructions, there is one on
Okay.
Anybody else have an attempt at this definition before Dean Dolan tells you we're looking for the criminal element. So we're looking for an act and we're looking for a mental state. Okay, David?
The deliberate intrusion into the space of another.
Oh, where did you get that?
I just
Made it up. Okay. All right. Anybody else want to share theirs before we go to the real one? Okay, the real one.
Okay, this is the definition, which you have to have memorized. Placing another in the reasonable apprehension of an immediate impending battery. Assault doesn't have anything to do with touching anybody. If you touch, it's a battery. So it is placing another in the reasonable apprehension of an immediate impending battery. So if I point a gun at you, does that put you in the apprehension of an immediate impending battery? Okay, so what if I say I'm going to hit you with a feather? I mean, you could, but probably not, right? But it's placing somebody, it's making them be apprehensive immediately. So placing another in the reasonable apprehension of an immediate impending battery. I'm going to shoot you with my gun next month. That's not immediate, it's not impending, right? So can you see? It's placing another. So you've got to have another. You can't assault yourself, right? In the reasonable apprehension. So it's not an unreasonable, ridiculous thing. I'm going to throw a pea at you. You know, we'll keep.
So what's the act?
Placing.
Placing. Do you see language in there regarding the assailant's, the offender's mental state?
Apprehension.
Well, that's, the victim has apprehension. So there really isn't anything there. Assault is considered a general intent crime. So the intent is impugned, meaning they did that placing affirmatively. They meant to do what they did.
If you want to modify it just to get it, it's intentionally placing another. Because now it's me intentionally placing.
Ooh, I like that.
Right,
And intentionally to the front
right.
of
You
that.
can in the beginning. Eventually you won't, but for now, that helps you to understand what the intent of the party was. Intentionally placing another in the reasonable apprehension of an immediate impending battery. So we're going to go over that on Saturday again. I'm going to have you all say it a whole bunch of times. So when you see an assault and the facts in the case, you don't have to think, gee, what is an assault again? You're just going to blab it out on the paper, right?
So did Michi commit an assault? Is that the crime that she had that we were trying to sentence her on? She picked up that beer bottle facing Kale, swung it at her. Kale knew it was coming because she ducked. And it was a hit and miss.
So how about this, Drake? Because it's sort of like what you said. What if he went to the restroom and he came walking back out and she was behind him and she swung the bottle and missed, but he didn't even know what happened? Yeah, right. So there's some variations on this. We'll talk about this for the entire year, but this is your first definition, your first rule statement, we call it. Intentionally placing another in the reasonable apprehension of an immediate impending battery. Okay? Every one of those elements has to be there.
So keeping those in mind, what are the elements of theft? Taking, carrying away, personal property of another with the intent to commit, with the intent to permanently deprive. So here's your hypothetical. Lady is loading her groceries into the trunk of her car. This is like a mini essay question. Thief grabs a bag of groceries from the cart and starts to run away. Lady yells, "Hey, that's mine." Thief swings the bag of groceries at her. She ducks and is not hit by the bag. The thief gets away with the groceries. How many crimes could be charged? And what are the facts to support them? This is a classic, although minimal, essay question. lady is unloading her groceries into the trunk of her car. Thief grabs a bag from the cart and starts to run away. Lady yells, "Hey, that's mine." Thief swings the bag of groceries at her. She ducks and is not hit by the bag. Thief gets away with the groceries. How many crimes?
What three do you have? Stand up.
Larceny, assault, and robbery.
Pretty good.
Robbery could be.
Could
I was
be.
thinking more of, yeah, it was in her cart, so it is from,
Through force and.
Some
Yeah.
level of force.
yeah, I was thinking larceny and assault for sure, but I wasn't thinking robbery.
Yeah,
That's a good
That's
guess.
great.
So do you see the facts? It's her groceries, personal property, in her immediate presence for the robbery. And he grabs, that's the taking, runs away with them, that's the carrying away. And before that happens, he swings the bag at her, hits and misses, that's the assault. And that's also the force, arguably, for the robbery.
So if
With
you
the
were
intent
writing
to
an
permanently
essay on
deprive.
just this little thing, you would start out with first issue, larceny. Go through the process. Next issue, assault. Go through the process.
Process meaning, rule
Meaning,
statement, definition.
Rule statement of what assault is,
Facts that are relevant.
placing another in the reasonable apprehension of immediate benefit. Was she apprehensive? Was she another officer? Was it immediate impending, right? And then you would go through larceny and give the elements of larceny, taking care of the property of another. And then the last one would be robbery, and you'd say, what? Taking and carrying away the property of another from the immediate presence of the person by force or fear with the intent to permanently deprive. And so you would have in your essay answer, because the answer might say, what crimes can doofus, whoever he is, be charged with? Larceny, assault, robbery. So that would be your essay answer. So it's real simple, but it takes a long time to get simple, okay? And you did very good in identifying issues that they call issue recognition. You have to see the issue before you can write about it. There has to be some basis in the factual scenario to see the issue. And I thought about the robbery as well, but I was interested that some people wouldn't get that. And so if your test was based on 1/3 for assault, 1/3 for larceny, 1/3 for robbery, and you didn't write about the robbery, guess what? You're not doing so well, right? And so you missed too many issues and you're dead. Even if you wrote phenomenal answers on the two that you got, if you missed one or two, you're dead. So that's a big part of it, issue recognition. How do I know what I'm supposed to write about? Well, there's certain keywords in there, right? You swung the bag, so that's probably an assault. But now, is there a robbery there too? Because it's now force or fear added to the larceny, right?
In her immediate presence.
In her immediate presence, right? So those are the two other things, right? Immediate presence, force and fear. So you gotta see that.
So I just want to point out one last thing, what Dean Dolan did, he did larceny first, assault second, and robbery third.
Right.
And the prosecutor in me would think, well, that's not the right order, robbery's more serious, let's start with robbery, larceny and assault. But they teach you, in order to write well and be read well by baby bar readers and judges of what you've written, to do it in what order?
Chronological order. What happened first, what happened next, what happened next. Even though, if you were looking at a complaint, you would say murder first before you saw burglary or something like that. But if the burglary happened first and then the killing took place second, you would go burglary first and then murder second.
And these facts are so minimal and so mushed up.
Right.
It's kind of hard to see that the logical, from beginning to end, it looks like it's gonna be a larceny. He's stealing the groceries. It's not till she yells, hey, that's mine, that he decides he needs to use force. And that force that he used is also called an assault.
So assault, and then, because now you've added the immediate presence and the use of force or fear, then you have a robbery.
Does anybody have any questions? I'd like to see that you're not completely dazed at 9:15 on night number 2.
It does take a while to get through this, and eventually it'll be real easy. We actually had somebody that was going to take the baby bar, and there was a car that was at the gate to get out, and then they were just parked there and they wouldn't move. And so the person from the car ran up and grabbed the ticket out of their hand, stuck it in the thing and yelled at him and all this. And then in the back they're going, okay, that's a false imprisonment, an assault, a battery, a robbery, and they just went through all the things that they just saw by somebody just doing that. That's eventually what you'll do. That's when you become absolutely weird to everybody that you live with. Because you'll see all this stuff eventually. It's like your antenna go up, and every time you see something, you go, why do this, and this? And Renee got good by getting the robbery in there. Like that's what you gotta do. So we'll work on that for a whole year. And then some. Okay. Anybody have anything they really can't stand to wait till next week for that? Okay, you can go home. You can go home early, 13 minutes early. See ya, Miguel. You did good.
Thank you.
Good work. Say hi to Aurora.
I will.
All right.
Bye.
She's on the screen in another room.
Yeah.
Just leave that for now.
Contracts, yes.
All right, everybody. It's the first time. You'll get used to it. Excellent work. You're good. You did good. Way to go, BB.
Good night, everybody. I'll see you tomorrow.
See you tomorrow.
You don't have to go home and study.
I tried to read, but then I fell asleep.
I tried to read last night, but then my eyes became blurry and I said, what am I doing?
I woke up with Chinese food all
Yeah, that's right. I got dinner and I go to sleep. That's great.
I think you're right.
See if they're reading for breakfast time. All right, see you tomorrow. Yeah.